David. 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 David, you're a dick. David. David.
Our David. David owned a brilliant gallery. David, are you a dirty peeping Tom?
David. David. David.
Is what's happening.
David. David.
David. David. David. David.
Oh my God, ew, David.
I forgot I had that video queued up, so I thought I'd play it. Welcome back, everybody, to Making Law Simple. My name is David Helm, a licensed practicing attorney in the state of Michigan. And today we are on day 3 of the Jennifer Crumbley manslaughter trial. If you haven't been keeping up with this, I'm not sure why. This is a travesty of a case. Ethan Crumbley was pled guilty and sentenced to unaliving 4 people at a school back on November 30th, 2021. And this is the trial for his mother. Both of his parents have been charged criminally with involuntary manslaughter. The state's argument is that they knew that their son had a mental health issue and was a danger to society at large, and yet failed to take the necessary steps to protect society at large from him, and in fact did the exact opposite by giving him unfettered access to a firearm. Now, in my opinion, none of that has been presented at all in the first 2.5 days of trial. At the most, he might have been a troubled teen with some odd quirks, but any attempt to say that the parents weren't diligent or staying on top of them or anything like that, I feel like that sort of falls on the wayside. There was plenty of video and text messages regarding finding a hobby for their son, that being shooting, actively engaging with him in that hobby. They took him to the gun range at least on 9 or 10 occasions that we saw evidence of, teaching him proper gun handling, gun safety, ownership, and things like that. And then also other text messages about concern for his grades and concern for his behavior and making sure he's sleeping and doing his chores and things like that. Now, the state has pointed to text messages regarding their horses, and that while Ethan was texting them, apparently in a panic that there were demons in the house, that the parents were at the horse and taking pictures of themselves at the horse. But that was somewhat contradicted, or at least ruffled a little bit, when the lady who owned the barn testified that cell service is kind of shoddy out there. Plus, there's no evidence that they didn't talk to their son after the fact anyways. Just because there's not a text message of it doesn't mean that they didn't acknowledge their son's text and discuss it with him later. At the end of the day, the real question is, are James and Jennifer guilty of essentially neglecting their son, who is a known danger? And do we want to draw a distinction on that? And do we want to establish some sort of weird liability for parents? The fundamental rule is that an intentional wrongful act of a third party is kind of an intervener between someone's negligence and resulting harm. Prosecutors' next witness is going to be the horse. Yeah, it's all kinds of it's just not a good case. Now, in fairness, I don't think the defense is doing the best job pointing that out, but I'm hoping the jury can kind of see through some of the shortcomings in the defense attorney's approach to this case. Thought we're not really hearing anything. Look at that. They're just leaving that math drawing up there on the board. Like it's nothing. Just leave it up there for everyone to see. The jury's going to come in and sit down, and it's just going to be sitting there. I think that's inappropriate. They should take the exhibits out down if they're not talking about them. I'm sick that the parents had to use their life savings against this, and then they've been in jail. Yeah, they've been in jail for 2 years. Yep, that's my thoughts exactly. Defense attorney is doing an awful job. However, Jennifer Crumbley should be acquitted despite that. We hope. Yes, I'll be covering James's trial in March as well. At least that's the plan right now. should nothing go wrong. Yeah, and they've kept the jury in for excessive arguments between. Yeah, it's just the judge doesn't have a handle on this courtroom very well. It is $500,000. So she is given bail, but it's $500,000, which is more than her house could cover or anything else that she had. Plus, it was $500,000 each, I believe. I might be mistaken. It's either $500,000 for the two of them, $250,000 each, which they couldn't cover, or it was $500,000 each, and it was $1 million. But either way, we can make it the smaller number. It was $500,000 for the two of them, $250,000 each. They still couldn't cover that to get out. So they've been just sitting in there in jail this whole time. And they're brought out in shackles, waist shackles and handcuffs and stuff. It's ridiculous. Yeah. They didn't unalive anybody themselves. They didn't pull the trigger. They didn't do anything. Crumbleys must be Republicans. Well, if they were Republicans, according to liberals, they would have way more money and they'd be able to post bond. This is the lead investigator, the one that's standing up from the Oakland County Sheriff. He's the one that's just going to sit there quietly. He'll eventually testify. He testified at the preliminary examination, so I imagine he'll testify at some point. It's a show trial. Yeah, I believe what the defense said. She quoted Taylor Swift, but she talks about, Band-Aids don't fix bullet holes. And what the prosecutor is trying to do is fix this, mass shooting, school shooting thing with a Band-Aid by making everyone feel better about it. Oh, we're going to prosecute the parents. It's not attacking the underlying problem. Yeah. What is the theory of danger? We don't know. So oftentimes in Michigan, I do it a lot. When somebody is potentially facing charges, I'll be on the phone or via email talking to the prosecutor, and I'll say, hey, if you issue charges, let me know. I'll walk my clients in on a warrant so that they don't get picked up and held overnight or, for an arraignment the next day or whatever. We don't want our clients spending any amount of time in jail if we can avoid it. So that was the same conversation they had here. The prosecution issued an arrest warrant for James and Jennifer Crumbley and didn't tell defense counsel, even though they asked to. They found out about it on a newscast. Then the attorneys are talking to the Crumbleys. The attorneys are saying, we're out of town. We're coming back. We'll walk you in on the warrant on Saturday morning. Just hang tight. In the meantime, they put out an all points bulletin and blasted all over the news. The prosecutors do, saying, we're looking for James and Jennifer. We're looking for James and Jennifer. They're on the run. They're on the run. And then they're found at a friend's place in Detroit and get picked up. And then the state uses that against them, saying they didn't turn themselves in, so they were on the run. So they're a flight risk, apparently, which has been ridiculous the whole way through. The whole flight risk thing is ridiculous. They also said that they have family in Florida. There was no attempt to go to Florida. They said that they had 6 phones, and they were using burner phones. Well, the police took 2 of their phones when on the day of, and then they bought 2 new phones, and then the police took those 2 new phones. So then they bought 2 burner phones so that they had some way to communicate with people, and then the police took those. So those were their 6 phones. They kept getting taken by police. It wasn't like they were using a track phone to run. It's just all kinds of shenanigans. And they weren't staying at their home because people were camped out on their lawn. They weren't on social media because they were getting threats on Facebook and everything else. So they changed their phone number because people kept calling them. But they were in constant communication with their attorneys, and their attorneys were in constant communication with the prosecutor's office. Can't heal until you get past the anger. The DA is feeding the anger. Yep, absolutely is. Yes, this is going to come out in court because the prosecutor, on cross-examining the horse barn lady, was asking questions about something. I can't remember exactly what it was. There was an objection as to the relevancy, and the prosecutor said it goes to flight. It's relevant because it goes to Jennifer fleeing. So they're absolutely going to bring this up. They're going to argue consciousness of guilt and she was trying to flee. Although I don't see why consciousness of guilt would apply to this case, because it's not like it's an intentional act. You have to be conscious of your intentional act. The other thing was, why would they need a lawyer so bad? Why are they so scared? Parents don't get charged with these things, yet they are. Why would you be scared to run? A parent's never been charged. So why would they be fearful and run? Unless it was purely for their safety because they were getting harassed by everybody. When the person going to testify from the jail? I don't know. I have no idea. I have no idea when anyone's going to testify. I don't even think the state knows. At least according to their statement on Friday. They don't know until the morning of who's going to testify. But we were sitting with the counselor. And speaking of counselors who should never be trusted, Ken, welcome.
Good afternoon. Nice to talk to you.
Nice to talk to you. How are you?
Not too bad. Was re-listening to some of the counseling or the counselor's testimony over lunch. And yeah, I'm kind of getting the feeling that he's trying to CYA pretty hard.
Yeah, did you watch his testimony at all during the preliminary examination?
I either watched you watch it or went back and reviewed it myself. I don't remember exactly, but he seemed very flaky to me in his responses when he did it the first time around.
Yeah. He's going to testify a lot about suicidal ideation with this particular case.
So did he rest, or did they not rest? Did the state finish already, or are they still going?
They're still going. He's trying to see all of the A. Yeah, that's exactly what he's trying to do.
Well, he said he had suicidal ideation. He went and called the parents, which was breaking confidentiality, which you only do if you believe that the person's at risk of harm. So, there's a lot of factors going in here, in my opinion.
I'd love to hear your thoughts going forward on that. Since you are in the field.
James Crumbley, case number 222799990 FH.
I have a question for you. We had a discussion about a juror last week. I think the juror, because I said if anyone approaches you or does anything, let me know. And I also.
Wait, what? Why are we turning the volume off? Was it you guys, WXYZ? Oh, God, I hate this. Let me see here. I wish there was a better way to do this. They just turned it off. Fix it, Dave. I can't. The feed is turned off. Now they've got the media spooked about juror stuff. Let me see if I can log in. I'm trying to log into the Zoom feed. Damn it, I missed it all.
I think we just have to have a court reporter if you go in chambers.
I don't have a court reporter. I think some people have court reporting in their office.
Yeah, down in Detroit, they bring it right in and do it.
We don't have any court reporters, but I think some people have video in their office.
Oh, yes. I would just request we do something where it's put on a record.
Yeah, but what do you want me to ask them? What do you want me to ask them?
I would like you to ask them if they have read any of the articles, because they obviously have knowledge about it. If they have discussed being a juror with anyone, if someone has approached them about being a juror, and then obviously can you still be fair and impartial to decide this case, or has that impacted you in any way, shape, or form? Is it possible to ask the courtroom to just clear out for a moment so we don't put him on the spot, but we quickly ask him?
I don't think that I'm allowed to do that.
I didn't know if you were.
No, you can't close the court.
I mean, I can talk. You mean with the juror here?
Apparently, a
You know,
juror
I
was
can,
contacted by media, it sounds like.
Ask if there's any. Can you find out if anybody has recording in their office? I think some people in the some family court judges have recording in their office because when they interviewed kids about placement.
That's correct.
I never had that.
Oh, you can
when
go
I was a
straight
family
down the
court
hall.
judge, but some people, I think Joan Young used to have it. So I can figure that out maybe. It's sort of less intimidating, right?
Yeah, I don't want to intimidate them by any means, but I think it's important we make a record.
Yeah, I feel like I'm playing the role of Miss Smith today, Whiskey.
I'm sure she's not here, so. All right. Okay.
Ken, you might hear some
Right now we're
feedback
bringing the jury in. Okay, we're gonna
because of the way I
check.
have this set up.
That's fine.
We're checking on the availability of a little room or.
I'm seeing if there is a judge in this
Oh, got
courthouse who has video. Oh, she does? Judge Brennan does. How'd you find that up so quick?
Probably Doug McDonald as well.
It's Ashley. Ashley's a superstar.
When would you like me to do this? Can I do it at the end of the day?
Sure, that's fine.
Isn't it gonna freak her out when I take her down to Judge Brennan's courtroom? She might think of going to Judge Warren's courtroom.
Your Honor, I would ask if we could do it sooner than later, just so that there's not any chance that if there is an issue, she could taint any of our other judges.
Okay, I'm just gonna bring her in then.
All right
'cause-
for the jury?
Recording in progress.
Recording, I thought was already in progress, but okay.
So what's going on? I think I missed something while I was lagging.
Yeah, so apparently one of the jurors, it sounds like, might have been contacted by media. There's also a concern. I posted in my Discord an article from the newspaper that identified the jurors by like occupation and everything else. Not names though.
Yeah.
And the jury seems to be concerned about all this.
Are they just trying to intimidate the jury or get the case thrown out? Because it sounds like that's what they're trying to do.
I have no idea what's going on.
Don't worry. Don't worry.
Like,
The other camera feed, they're covering it. They're like, he just put his hand over the camera. I don't know what's going on.
Juror number 5. I don't want to make you nervous. What's that? Oh, the jury's never on here, right?
Yeah, I'm not showing that, but I just want to make sure the audio part. I've got my hand over the lens, Your Honor.
Okay.
So, but it's just these proceedings right here are off camera. You want, ma'am?
I would love it. I don't know if I'm yet allowed to ask you to do that though. Am I allowed to ask you to do that?
Judge doesn't know her own rules.
Thank you. So you're off, right? This will take just a second. Thank you.
I mean, I think the judge doesn't know her. I'm gonna not make some mean comments right now, but
Uh-oh.
is
All
it
audio
necessary?
off.
Is it necessary for there to be that many bailiffs for this case? Because that seems abnormal.
I think it's mainly because of the high profile nature of the case more than anything. We're only a week out or 2 weeks out from someone trying to jump the judge. People
This
try
is
to jump
true.
defendants. We have no audio right now. So they
Because
cut the court cut the Zoom feed as well.
Someone mentioned earlier or the other day that it kind of seems a little prejudicial to have all those bailiffs in here. It gives the impression that the defendant's a threat.
Yeah.
I don't know if it would stand any merits on a challenge, but I think
No, generally not, but they are like all lined up there, right? It looks kind of intimidating.
yeah,
I
like
guess
if
the
I
people
was,
that aren't normally in court, like I'm always used to seeing bailiffs in court, but yeah, you're right. It is quite a few. Why does a judge not know if she can do that? Well, because it's an open courtroom and it's supposed to be for the public. And everyone sitting in there is now hearing all the testimony and listening to the jurors. And So the judge is concerned that us viewing from home should be able to see this as well. Let's see. Yeah, see, that was the idea. I thought we were going to be able to hear and not see, but we don't have any audio right now. So it sounds like juror number 5 was specifically questioned. Now, juror number 5 is a white female. She was married. She has guns in the house and says that they are locked up. She has 2 grown children and recalls taking gun safety classes as a family when the kids were in elementary school. She works for a bank and her husband is in advertising. I feel like I can be fair, she said. That's what we know about juror number 5. So maybe she was the one approached. I don't know. Ooh. So we have an update too on Florida v. Menez. It's pronounced Menez, right? Or Menez. That's that case with the immigrant that speaks ma'am. Apparently there was a motion to dismiss that was filed today. So cool. I'll be bringing an update on that for you guys shortly. Well, while we're waiting, I guess, Ken, what are your initial thoughts about this counselor and his assessment and his approach to everything that you've heard, right? So we have, if I was to, let me go back here real quick and just see kind of where he testified and hit some highlights. So he said that the vid was tough on kids when they came back. On May 13th, 2021, there was an email that said, would you have a chance to talk to Ethan because he's been sleeping in my class?
Mm-hmm.
And he doesn't remember having the meeting with Ethan. He doesn't remember reaching out to the parents. And then there was an email on September 8th. Could you please touch base with the student? I'm reading some of his poems. He says he feels terrible and his family was a mistake. He says he spoke with Ethan. He did not speak with Ethan. He spoke with his teacher. What are your thoughts on not speaking with Ethan?
I mean, if there's a potential for the kid to have, like sleeping a lot in class could be just being tired, or it could be indicative of other things going on. The depression causes lethargy or people not wanting to get out of bed or sleeping a lot. So, I mean, I would want to say, hey, what's going on, buddy? Why are we sleeping so much? But again, that's me.
But they didn't talk to him. Do you think it's unusual that they didn't talk to him?
Probably for the school, probably not, because they probably look at it as more of a discipline thing than as a mental health thing. Not that they shouldn't, but that's probably, I don't know how big the school district is, how many students are in the school. And, like my graduating class had 100 people. My wife's had like 1,000. So when we graduated high school, so there's a difference there. So the school and how many people that, how many staff like the counselor has for how many students, I could see not doing it because it doesn't seem like high priority. Again, it's also easy to miss things that are important too.
That morning, did both Jennifer and James Crumbley come to the school?
They did.
Okay,
Sorry, I didn't mean to cut you off. I was trying to set up all this because I have
you're
I had
good.
various screens going. So I just wanted to back this up a touch. Yeah, see, that's what I thought was kind of weird too, that he wasn't reaching out to the student in that moment, just speaking with the teacher and then nothing else. And then when he did speak with the student, again, he didn't then follow up with the parents.
What to me was the most like when I was re-listening to it, because I heard most of it, but I was like driving, so I couldn't like completely pay attention. But I re-listened to it a little bit before I jumped on, and he's got a master of counseling, so he is a counselor. He's probably master's level licensed, which is what I'm at. So he's legit. So he's not just like filling the space and just doing scheduling. He knows the procedures. He knows how to do therapy basically. And because he says he's master's of counseling, and then he says that he sees the paper. He's worried about self-harm. He contacts the parents because that's the protocol for someone who's at risk of harm. You break in confidentiality. You typically only do that if they're a threat of harm to themselves, others, child or elder abuse, or if you're being subpoenaed and you have to testify. Outside of that, you can tell me you've murdered somebody and I can't tell anyone else unless you plan on doing it again.
It's like attorney-client privilege.
For the most part, yeah. Like I legitimately use that when I introduce myself and do my first session to show just how serious confidentiality is. so that
Yeah.
people will say, hey, he's not going to really say anything to anyone else. So, you know, I say, you can murder somebody and tell me, and I'm not
Future
telling anyone
issue.
else.
Like if you
Yeah.
feel like he might commit self-harm or something like that, then you can address it, right?
Yeah. So if,
not past
so
stuff.
if, yeah, so past stuff, it's like if someone tells me, you know, I was abused in the past, or you know, and it's been dealt with, like they went through all the CPS stuff, or you know, I was, you know, self-harming or suicidal in the past, but it hasn't been for a while, I'm not immediately concerned. You know, if there's enough information to make me concerned, or if the person's saying I am worried about, you know, self-harm, then that's something I want to look into further. So like I've been saying in the chat is, when we do like suicide assessments to involuntarily commit someone, we typically need, the way you're supposed to do it, let me phrase that, not that everyone does it this way, is you're supposed to look for three things. They have the intent to do it, a plan to do it, and a means to do it. And so it's like, okay, can they jump off of a bridge? Like my plan is to jump off of a bridge. Is there any bridges anywhere near you live? No. So that's not really feasible, you know, or I have a knife. Okay. Do you know how you do it? I'd stab myself or I cut my wrist. Okay. Do you want to do it? Yeah, I'd like to die. Right there. Those are all the three. Okay. Involuntarily committing. So
yeah, and so he's going to talk about, it sounds like they're getting into the meeting, and I'm curious to see what you think about this, the meeting with the parents, because I don't think it goes the way it's supposed to.
Oh, it probably doesn't.
Go ahead, Pastor.
Thank you. Okay. Mr. Hopkins, when we broke for lunch, we were talking about the phone conversation you had with Jennifer Crumbley when you called her in.
Oh, it's already
Yes. Okay. So that morning, did both Jennifer and James Crumbley come to the school?
They did.
Okay. Do you recall approximately what time?
I believe it was around 10:30.
Okay. Now, if I were to tell you that we had video surveillance that showed that you welcomed them to your office at 10:40, would that sound right?
That sounds right.
Okay. So walk us through what happened from the time that you were notified that James and Jennifer Crumbley were there to the time that you went.
It was weird.
So when I was notified that they were there, I had actually texted Mr. Ejak to please come back to my office. He had been present through a majority of the meeting until we confirmed the parents were arriving, and then asked him to return. I then went out to the lobby of the counseling office area to greet the parents.
Okay. So from the phone call where you actually spoke with Jennifer Crumbley was 9:27 a.m. From that point, 9:27 a.m. until 10:40 a.m., where was the defendant's son?
In my office.
Okay. And what was going on there?
There was a conversation between myself, the defendant's son, and Mr. Ejak was there as well until approximately 10 a.m. During that time, I was still trying to affirm that parents would be able to arrive, and I was talking with the student about really what I was going to be sharing with his parents.
Okay. And tell me, sir, what was your expectation of the result of that meeting that you called?
My hope was that they would set a plan to get help for their son.
Okay. Was your expectation that they would take their son home?
That was my hope.
Your hope. Okay. So at 10:40 a.m., you welcome them into your office. Tell me what happens next.
We walked back into my office. The student was in there. And then mom and dad sat down. There were 3 seats in my office, 2 directly across from me, and then one that was kind of off the corner of my desk a little more. The student was in one of the 2 across from me. Dad sat in one of those, and mom sat in the one that was more at a diagonal from where I was.
When the defendant and her husband walked into the office, did they approach their son?
Not to my memory, no.
Okay. Did either one of them hug their son?
No.
So who started the meeting?
I believe I did, and I went over some of the things that I had talked through over the past 2 days with their son. I wanted to confirm some things I wasn't sure of, so I confirmed with mom that she did receive a voicemail from Miss Fine the day before, and just confirmed that what was stated in that meeting was true.
Ken, just so we have a bit of a more background on you, have you ever dealt with children? Were you like a school counselor or anything like that, or are you just a general counselor?
So I've worked in several different environments. I've worked in private practice, like, the typical what most people think. I've done in-home counseling where people will usually get referred through like Medicaid or whatever. And we go and either meet the kid in school or at home and do the counseling there. I would typically meet at the home because I didn't want to, A, take the kids out of the class, or B, have them worried about, hey, why are you leaving class every Wednesday at 2 to go for an hour? Where are you
Sure.
going? So there's none of that. So they don't have to worry about the stigma.
I'm just
And
wondering
then
if the hugging thing was like a red flag for you or at all, because it seemed to be
Not
for him.
Not necessarily. I've had clients inside and outside of my office who, some people just don't always embrace their children like that. Doesn't mean that they don't do it in other ways or at other times. I've had kids who were in very, severe situations, and, their parents, while caring, maybe not have embraced. It didn't mean they didn't care. It's maybe something to think about, but it wouldn't be like, oh my God, red flag, or they're abusing them. There's plenty of other things that would worry me first. So,
Okay.
And mom confirmed that she received it and that was true. And then I went over some of the things that I had received messages of from the teachers over the past 2 days.
Okay. Now, when you were asking Jennifer Crumbley to confirm that information, was she sharing any additional information with you?
See, like my wife, who's the stepmother to my son, would be like, "Don't do that. You're going to embarrass him," Because I always like when I'd go to like band concerts and stuff, and I'd be waving and want to take pictures. She's like, "Quit embarrassing him."
My memory, no.
yeah, that's about right.
Now, describe Jennifer Crumbley's demeanor when she walked into your office.
She sat down in the chair, felt a little bit distant.
What do you mean by that?
Fiction?
More just kind of like, it felt like it was a little bit of an inconvenience to be there.
Okay, you testified that you had to have these meetings in the past.
Yes.
Was this meeting similar to those meetings, or was it different?
Your Honor, objection to relevance.
Relevance, also
So
lack of
it's
foundation.
relevant because the crux of this case is the defendant's failure to use ordinary care.
Lack of
to avoid,
foundation.
A tragedy, and her failure to use just ordinary
Object
care
again, lack of
contributes to her
foundation.
failure
Get it in
to
there.
adhere to her parental responsibilities, which is her duty under Michigan law. It's all part of gross negligence, Judge.
Well, I guess was the meeting unusual in any way?
Lack of
How many meetings
foundation.
like this have you had?
In order for
Parents,
something to be
example.
unusual,
Dozens.
you need to establish a foundation, right? You need to establish something to compare it against. There's no foundation. She didn't object the right way. Sorry.
Dozens, okay. So, people react differently to, no one's very excited about coming to this school about their child, right?
I would agree.
Now, this wasn't a discipline issue, though, was it, sir?
No.
Okay. In fact, you had indicated, Jennifer Crumbley, that you had concerns with suicidal ideation.
I had concerns for his well-being, absolutely.
And you
Okay, you son of a, you slimy mother.
Yes.
Ooh.
What
that's your-
popped out at you right there.
Oh, because he just said, like, right before the break, he had, there was concerns for suicidal ideation. You're contacting the parents because, hey, I have to contact your parents, which means I have to do something, or he's going to be in trouble probably. And now you're saying, oh, I just had concerns for his well-being. This is that crap that he probably did during the preliminary, if I'm remembering. Oh my God. This is one of those counselors that irritates the shit out of me, pardon my language.
He bugged me the whole way through too, but I'm not a professional in this industry, so I'm glad you're on board. Since Jung refuses to come on with me,
And yet, still, it was different than the dozens of meetings.
she's
we had
concerned she'll
past.
say something.
I would agree.
So you said that this defendant's son sat directly across from you. James Crumbley was in a chair next to him. Jennifer Crumbley was off to your side.
I don't remember which chair student and dad were in.
That's
I know
fine.
they were both across from me, and Jennifer Crumbley was off to the side a little
Okay.
more.
So you were asking them to confirm the voicemail, information left in the voicemail November the 29th, the day before?
Yes.
Okay, specifically, what information were you asking them to confirm?
I asked first if they received the voicemail. because I didn't know.
Farrell
at
will
that
never
point
stream
whether
with
they
me.
had or
She
not.
refuses.
And then I asked to confirm the details of the voicemail, which were that shooting guns were a hobby that they undertook as a family and that they had went to the range over the weekend.
Okay. Did you tell Jennifer Crumbley that her son expressed to you his own feelings of his friend leaving the state?
I did mention that, yes.
Okay, and what else did you mention?
I mentioned the conversations I had with the student of the friend leaving, that the student was sad about that, the dog, family dog passing, grandparent of COVID being hard, and all of those which were told to me by the student were also confirmed by the parents.
Now, when you say confirmed, I take it that, I don't want to put words in your mouth, but this didn't catch Jennifer Crumbley by surprise.
It did not feel as though it was new information to the parents.
All right. Now, you testified that it was your hope that they would take him home that day. What do you mean by that?
I wanted to make sure the student was able to get the support that I felt was needed, and I was wanting it to be as soon as possible.
Okay. Did you feel like that he could be left alone at that point?
I did not want him left alone at that point. In fact, that's why I kept him in my office until I could make contact with parents.
Okay. And you communicated that to the defendant?
I do not remember if I communicated that to the defendant.
Remember, just earlier today, there was a message sent from Jen to the horse lady that said, if I come out later, I'm bringing Ethan with me. He cannot be left alone. So obviously that was the same day. That was after this meeting. That was like within a half hour after this meeting. So that was resonated with her, and she realized that he could not be left alone.
If you're telling the person that their child can't be left alone, that's not done. You don't do that for like no reason, right? So one of the places I worked at was not like a true like inpatient facility. It was kind of like a mix between, it was like a homeless shelter for youth, but in respite care. So like you could, like if you and your kids were having like major issues, you could drop the kid off for a few weeks. They get therapy and other stuff, and then they go home. So we couldn't force them to stay there, so they would run away a lot. But, you know, if we had these, what I'm getting at is we had this, the way that the federal and state laws required us to do it is if a kid was at harm of them, like had like suicidal ideations or anything, but it wasn't enough to send them involved to do like a 72-hour hold, we would put them on something called sight and sound. Basically, they had to be within sight and sound of staff members at all times.
Well, this is the thing too, is that if he's at risk of self-unaliving and he is at school with people, he's not left alone, right? He's with teachers, he's got kids running around. There's a lot of people going, you know, around him until such point that maybe the parents can line something up. None of this makes sense as to he needed to go home immediately. Well, if he goes home immediately, parents have to work. So isn't it better for him to be in school with teachers and this guy and principals and everything else?
So if I take the assumption that if I'm working from his perspective and he's thinking of a self-harm problem, that it makes sense to keep the kid in a situation where he's not isolated, where he's got peer support, where he's got staff and other people there to, you know, kind of keep an eye on him. But, you know, not necessarily to the point where he's, you know, oh my God, he's going to, you know, like I've had clients do, like literally break a plastic sign and keep it as a way to cut themselves. But he's not in a good spot. We'll keep him until parents can figure something out. It makes sense in the moment. When you try to retrospect it like they're doing here, now it looks all bad and it's all the parents' fault.
Right. It looks bad only in hindsight because of what he did. If he went home that day with the parents and nothing else materialized, no one would think this was bad.
Or if he went home that day and the parents went to work and he killed himself, then people look at the parents as, oh, you left your kid who was suicidal, you know, like either way.
That's true.
The problem is there's really no right answers in a lot of these situations. There have been situations where I've had to, with my training, my education, you know, bachelor's and master's degree, different trainings and stuff. I've flown by the seat of my pants and I've made shit up on the spot to try and figure out a situation. because
Yeah.
there's nothing else that you can do. Like there's nothing, they don't write a book for this, like kind of
Well,
thing.
that's kind of my point. They don't write a book for this. And if you guys look at my video on the witness or on the expert witness, it's clear that even the experts that have been studying this for 20, 25 years can't predict this stuff. So
It's not predictable.
Yeah.
There's just too much of the human condition that makes it, it's not an equation you can plug numbers into. You can get
Right.
maybe statistic, like maybe point that these certain
Well,
criteria
statistics,
make
but-
you more, yeah.
An individual is above statistics, right? You can cite statistics all you want. At the end of the day, this is an individual that's going to make their own individual choices.
Exactly. So yes, they might be more at risk, but that doesn't mean they're going to do it. Just like I could pull the statistic out of, people who were victims of child sexual abuse, themselves have a higher incidence of being offenders themselves, but that doesn't mean that everyone who was abused is going to be an abuser. That
Right.
was a thing for a while where they assumed the people who were abused were going to end up abusers. And
Yeah, I remember
thankfully
that.
we don't do that anymore, but
Thank you, Straight. Yes, Straight put a link to that. If you guys are at all interested in that. The judge denied it, so they're not going to be testifying. Thank God.
When you discussed, well, first of all, did you communicate your hope that they take him home to the defendant?
Yes, my words were, I want him to be seen as soon as possible, today if possible. And I actually provided a list of mental health resources and handed that to Mom.
Now, when you say a list of mental health resources, could you explain a little bit more what that means?
Yeah, it was multiple pages of different services throughout the area, what they specialized in, whether they accepted insurance or not, and contact information for those different therapeutic options.
Okay, and that was actually provided to the defendant and her husband?
I handed it to Mom.
Now, when you communicated your expectation, what was Jennifer Crumbley's response?
I didn't feel as if it was going to be an absolute no, but it was made quite clear that it wasn't possible to do it that day.
Why do you say it was made clear it wasn't possible to do it?
That they had to return to work and they were unable to do it that day.
Well, who said that?
Mom.
Mom, is it Jennifer Crumbley?
Yes.
Did she speak for James or did James speak as well?
I don't remember James speaking on that topic.
So what happened next?
My comment was, then I said I'd like to see him as soon as possible. Today is possible. I was told today is not possible, so I said, is 48 hours possible? I will be following up.
48? I thought he said
Dozens of meetings in the
24.
past, and
He did
anyone
say
ever
24.
said that he couldn't
At the preliminary, right?
go with them that
I
day?
think so. Well, he just
I
said he
did
wanted
not
them
have
seen
that.
today. So
Well, he said today, but if not possible, like today, within like the next day. I
That
think
would
is
be
how
within
he
20
testified.
yeah, that would be within 24 hours. I mean,
Yeah.
if he's not at imminent, like that's the thing is, and I think people who've watched it's not you, but like people who are following this don't seem to understand is just involuntarily committing someone because they have a thought of a suicidal ideation is not the right way to do it, and B, it's more damaging than not. I could pull
And
up.
it's not like you could just walk to a hospital and say, "Here, take my kid." It's a process. It's a process
mean-
that I have personal knowledge of dealing with this sort of thing. It's not something that can just be done.
You have to, a therapist can do it, like like in Florida, for example, because I used to be in Florida. We have the Baker Act, and there's a form and everything, and we fill it out, and we can have the police either transport them or EMS transport them, depending on whether or not they're
I don't think this guy is qualified to say it. Like if you got in front of a psychiatrist or a medical doctor, they could say it. But this guy with a master's in psychology or whatever, I don't think is qualified to make a report and have someone committed. I don't think he is one of
if he's
he
a
could be-
licensed counselor in the state, most states allow their master's and doctorate level therapists to do that because it's something you'll encounter. Like at the master's level in Florida, you can Baker Act someone. You don't have to be a psychiatrist or psychologist.
You can't
because
do that in Michigan. You need to get an involuntary hold, which we can do a 72-hour hold, but you have to get it authorized by a doctor, someone who has a doctorate, in order to sign an affidavit and say that this person is a danger to themselves or others. There's also another one with regard to people that aren't taking medication. If they're not taking medication that's prescribed, again, we could do it that way too, so that they get stabilized on their medication. But you need someone with a a doctor level. I believe I might be mistaken on that, but I'm pretty sure every time that I've done it, it's been with a doctor.
It'll typically say I don't know. Again, I'll see if I can find it, but typically it's someone who has
This is
a
a
mental
school
health
counselor, Jung, but he's got a master's in
He's
psychology.
a master of counseling.
Master of counseling.
Never, I would object to the relevance.
Same response as last objection.
Okay, well, I guess you'd want to back up even further. Have you ever asked parents to take their
This
child?
camera's
home
in a
that
different
day?
position.
Have you
It's
ever
awfully
requested
close
that?
to the juror box.
I've
Look at that. That's the
encouraged
juror
parents
box right
to be
there.
able to
Sorry, this is the juror box right here. That's awfully close.
get their son and or daughter help and therapy. I had never had it where it was feeling like I needed to push to make it happen.
And you say the feeling like you needed to push to make it happen. That's what you're experiencing November the 30th, 2020.
That is correct.
Okay. So tell me what's going on through your mind at this point.
I was a little caught off guard and a little confused because it was something that I wasn't really expecting that type of response, especially when parents came, and in fact, both parents came, which I wasn't expecting, nor did I request. I was a little surprised at their willingness to come, but then not completely follow through.
Okay. Now, you told the defendant or husband that your opinion was this drawing showed suicidal ideation. Is that right?
That was my opinion, and I did not. I saw it as somebody who was showing signs that could be associated with suicide, and so I took that out of just an abundance of caution, wanted to make sure that the student was able to get help.
Okay. But you communicated that to the defendant.
I did.
I love how that goes from suicidal ideation to the might be things that are suicidal
I asked
ideation.
them to take him to get help and therapeutic help.
That's different, right? Because they're still
Now,
not
when
sure.
It was made clear to you.
Yeah,
that
he's not sure at all.
Jennifer Crumbley was not going to take her son home, and neither was James. What is your next step?
I'm
My
looking
next
up the
step is
standards here in
trying to think of
Michigan.
what is best for the student in front of
I did find it.
Okay. And tell me about your decision process.
When I looked through it, it was clear they weren't going to take him that day. So my first thought was, I don't want him alone. I want to make sure somebody who's experiencing.
Why didn't you want him alone?
Because I don't want a student who may be suicidal alone.
Okay. I cut you off. Please continue.
I then, after determining I didn't want him alone, I went through different options of what needed to happen. At that point, the student had requested to be able to stay in class. And
So in Michigan, you need a certificate must be signed by a physician or a licensed psychologist. So that's what you need.
It's not a mental health. I thought I just saw something in one of the laws I was reading that did say. I'll see
Nope.
if I can. That's really.
Yeah, no. So proceedings under the mental health code. If you seek, let's see, a petition that may seek relief under the under subsection A, B, C, and D, 2 clinical certificates are required when seeking hospitalization or a combination of hospitalization and OA or AOT, which I think is like on-site, whatever. One certificate must be signed by a physician or licensed psychologist. A certificate is obtained by a person initiating proceedings within 72 hours after the hospitalization, before the filing of the petition, or after a court-ordered examination of the person initiating the proceedings, made reasonable efforts to secure an examination. So you can do it if you've made reasonable attempts to secure an examination, but otherwise they want it signed by a physician or a licensed psychologist. So that's what I'm saying. It's not that easy. Like if you're a parent, you got to take then your kid to the ER, and you got to get a doctor to sign off on this.
I've never heard of that before.
Staying in class is a good placement. I was with our dean, who would be the person who does discipline. And of the 4 adults in the room, I'm the one who can't remove a student from class. So I asked our dean if there was any reason from a discipline standpoint or anything that he needed to do from a discipline standpoint that would prevent the student from returning to class.
And the response there?
No.
I'm still reading more to see if that's something
So,
like another
You
little
told us that you
loophole
were
or something.
taken aback.
Yeah, I'm trying to find it
You
too.
were a bit confused by the response.
I've got a
of the
little
defendant.
cheat sheet. I've got a Institution for Continuing Legal Education, which is the Michigan-based. It's like a form bank thing that us attorneys can get access to, and it gives us like procedural guides. So, like if I wanted to file one, these are the steps, and that's like right at the top. It's like you need to get a doctor or a psychiatrist to sign off.
Because sometimes it'll be like it can be initiated by someone, but it has to be reviewed by like a psychiatrist or psychologist within so many hours or whatever. So that way it's verified. And if not, then they can
Yeah, like I said, you could do it if you sign off that you've made reasonable attempts to get an evaluation, and then an evaluation needs to take place within 72 hours, but the psychiatrist who examined the individual within 24 hours of the hospitalization. So they need to have been someone that's examined the patient within 24 hours, between 24 hours and 72 hours. So you need like 24-hour observation in a hospital setting, and then between the 24 and the 72 hours before the filing of the petition, or after the petition is filed by court order. So you can do another evaluation after the court signed an order. But you basically need 24 hours of hospitalization observation or a treating physician. That's what we're looking at. Again, I'm just trying to like skim through this real quick as we're here live, but
No, you're good. Say, I definitely don't see anything for master's level. That's so odd.
Is that when you turn to Mr. Ejak and requested information regarding discipline?
It is.
Okay. And how did the meeting end? Tell us about that.
The meeting at that point ended fairly abruptly.
What do you mean by that?
Well, at that point, we had a student wanting to return to class.
It's a good point, Julie. You should put it in the chat.
To be removed to go get therapy that day. So I was kind of left with an option of, okay, this student, I can't keep a student from class if there isn't a reason to keep him from class. I asked if there was a discipline reason, and once we had kind of gotten to that point, I allowed the student to go back to class based on the information I had, and then mom asked if we were done. And
Those were her words. Are we done?
Yeah. Yes.
What was your response to that?
My response was, I guess so.
Now, you let her son go back to class before James and Jennifer left your office. Is that right?
There was a short time overlap of maybe 1 minute.
So tell us what happened when it was communicated to the defendant's son that he could go back to class and he left. What happened in that time?
There wasn't anything noteworthy or different than any other student I've had leave my office. I wrote.
Yes, Jung. Most hospitals have a psychiatrist on standby that can do an assessment. Also, particularly in Oakland County, there is a public mental health program that you could essentially just walk into. There are resources available, but the law still requires observation and a doctor to sign off on.
Pass to allow him back into the classroom, and he had his belongings and went to class.
When he left, did either James or Jennifer hug him?
Not to my memory, no.
Did they say anything to him?
Not to my memory.
Did you say anything to him?
I did.
What did you say?
When I handed him his pass, I just let him know that I cared about him.
And why did you say that?
Because I do. Like I did. It was an hour and a half with a student who is sad, with a student that we were talking about future plans.
Now, in the time span from when you wrote him a pass
Oh,
and he went back
pediatric.
to his class, and James and
Either.
Jennifer were still there, did they continue discussion without him?
I don't remember any.
Okay. So what happened next?
I had handed them the sheet with referrals, and to my memory, they gathered up belongings and left.
Now, what was your plan as far as follow-up had this attack not happened?
My plan as far as follow-up was I was going to meet with the student the next morning to see if there had been more discussions and more plans about getting help. And then if there had not, my plan was to call Child Protective Services.
Now, how long would you say the meeting lasted from beginning to end?
Less than 15 minutes.
All right. And again, was that typical or atypical from these meetings that you've been in before?
Objection.
Same response, Jeff.
In your experience, how long do these meetings usually last?
They vary. I mean, I've had some where parents came, got their kids, and it was 5 minutes. I've had some where we were in my office for an hour.
So the instance.
So this was middle of the road.
It was quick.
Could be, yes.
Middle of the road.
Average, right?
Yes.
This lasted 15 minutes. You said there's some that last 5 minutes or some that last an hour. So this
I've
is on
had
the shorter
sessions
side.
last like 2.5 hours because the patient was in crisis. Like
Well, but
it
he's
depends.
saying an hour, 5 minutes to an hour, and they were 15 minutes. Okay, so they're right in the middle.
I mean, I've
Ish.
had people resolve themselves in 10 minutes, but they are also not that big of a deal. And we were able to work out a quick plan. Like, because especially when I was doing the place that was, the more residential place, people were in and out of my office all day. I could see them as much as I wanted, which was kind of nice. But, they would have something come up or they get into an issue or an argument with another kid. Hey, Mr. Ken, can I come talk to you? Sure. This is what happened. Okay, cool. Let's try this and see if it works out. Okay. And then I'll follow up with them later. Okay, everything's good.
It's not like a quick little fix. This is a process, right? And depending on where you gauge people in that process. Cheryl, thank you very much for the $10 super chat. My child made a comment and I was told that I had to remove him from school and take him to the counselor that day. That was many years ago. So what has changed in Michigan since the 90s? I honestly don't know.
Sounds like they made it harder.
Yeah, I never made a comment that people asked me to be removed from school. I think what this guy was testifying to, like if it was a disciplinary thing, like if he acted out in some way and it was a disciplinary thing, then they would have him removed from school. But there's no reason why he couldn't order the parents to take him home and say, hey, we're not taking him. You got to take him home. We're not going to keep him here. I feel like the school was in the ability to, had the authority to do that. They just chose not to. And who knows? I mean,
if they're working off the assumption that the kid's wanting to self-harm, not outwardly harm, so it makes sense not to send him home until that you can establish either A, treatment, or B, somewhere safe for him to go, like, grandma's house and grandma can watch him or something like that. That's not what we're doing here. We're working off of this assumption, like someone said, this kind of misdiagnosis of suicidal ideation. And like someone else in chat said, is it the counselor's fault for misdiagnosing it? There's really not too much to, the drawing in retrospect looks like homicidal, but it can be interpreted a variety of different ways. I could think of 10 ways to interpret that drawing.
Jung, I did see your comment. I ignored it because it's silly. I believe it's people's spending habits. Why did she spend $5,000 on a horse instead of keep that in savings so that if she needed to take a day or two off work, she would have the money to live off of? That's not the employment. That's people's choices.
That's self-control.
Yeah, one more here.
Yeah. I know, but you were being funny, Jung.
Nothing further. Thank you.
Thank you. Good afternoon.
Oh,
Mr.
cross
Hopkins.
already. Wow.
Good afternoon.
My name is Shannon. I represent
That was quick.
Mrs. Crumbley. When I'm asking questions today, if I ask anything confusing, can you please slow me down and let me know?
I will do so.
Thought this guys could be on the stand a lot longer on direct.
It's true that you are licensed as a school counselor, correct?
That is correct.
What does it mean to be licensed as a school counselor, or what does one have to do to obtain a license?
You have to graduate with a degree from an accredited university and meet all of the standards of the state of Michigan to become a school counselor.
And obviously you did that.
Yes.
Can you give us some examples of the standards?
I have to meet the required trainings based on hours over a certain period of years.
Do you recall how many hours or?
Well, they're broken up into specific categories, but in totality, it's on top of the degree, 150 hours every 5 years.
150 every 5 years. And you just mentioned that they're broken up into categories. Can you just give us a quick idea of what these categories are?
Yep, some are based on college. They have to be hours specific towards helping students get to college. Some are based on careers, and some are more general.
Are any of those based on suicide prevention or danger at school or discipline?
Those hours are not, but a degree in counseling is.
Ooh.
Okay, she's going somewhere.
Aside from receiving your degree and those 150 hours of training, or hours that you had to obtain your license, did you have any other additional training or continuing type education regarding becoming a counselor? Or,
Yes.
Okay, tell us about that.
The training is continual and goes well above and beyond 150 hours. It's oftentimes based on school need and oftentimes based on what is important in the profession.
And when you were testifying, did you say you graduated in 2012?
No,
I'm sorry, 2009?
I graduated undergrad in 2009, master's in 2015.
I'm sorry, okay, master's in 15. And at what point did you become licensed? Were you licensed, what year?
I passed the school counseling exam in the summer of 2014.
Okay, so starting in summer of 2014, you had to do at least 150 hours every 5-year period, correct?
When I was hired in 2015 and had the full licensure, I did 5 years, renewed my license in 2020.
Did you do the 150 hours or did you do more hours?
More.
Can you give us an idea of how many hours?
Significantly more.
Okay, when you say
So it doesn't-
significantly more, are you talking double the number of hours, 50 extra hours?
I wouldn't keep track of all the hours that far beyond, but
Build him up to knock him down. I like this.
Okay, I understand, I just don't know.
more than 200.
More than 200, okay. And then, again, you've continued since that time when you renewed your license in 2020 to keep getting more and more hours, correct?
Correct.
So by 2021, it's fair to say you had over the 150 hours you needed, the additional hours you talked about, and then you had already started moving on into the 150 you would need for renewing your license for the next 5 years.
Yes,
Okay, did I say all that right?
I believe so.
Okay, thank you. Now,
She was gonna be like, no further questions.
when I want to go back through the exhibits that Mr. Keast admitted while you were on the stand. And if you need to see any of the exhibits, please let me know. I'm going to start with 155.
So you need 30 graduate level semester hours to be approved to be a school counselor, resulting in a master's degree, an internship of not less than 600 clock hours based on approved school counselor program, and then at least 300 of 600 clock hours shall be in the school setting. That's what you're telling me, Ken?
Yeah, so the school counselor is like less than, say, like a clinical
Less than half
counselor.
is qualified.
So, for example, in the state of Florida, so each state has a different.
Oh, is that
amount
Florida? Or I thought that was Michigan, you said.
No, I sent you Michigan. So that's
Oh, okay.
Michigan's requirements for school counselor. So it seems like I don't know what their hours for clinical counselors are, like a licensed mental health counselor, but in Florida it's like 1,500 hours of clinical contact.
But he
In
just
the
said
state,
he only needed 150. But what you're telling me here is they need
Those
at
are-
least 600.
those are continuing education hours, I think, that they're talking about,
Oh.
which is kind of a stupid point to hit on. I don't know why the attorney's doing this. It would be much better to focus on the fact that he's had to do a graduate program that went into, like, I'm assuming, I would hope she did her research, that he went to school for a master's degree that was this many hours, that required this much kind of curriculum on this, that he had 600 hours to get licensed, that he had to pass exams for that, and he's required to do these in-service hours, these continuing education requirements, so that you stay up to date on stuff. It's like most professions these days. You have to do all this crap training every so often. Most
Yeah, I
of it's
agree.
like PowerPoints and stuff, but
Yeah, no, I agree. He wants the parents to be held accountable to take the blame off of him.
Oh,
He's
absolutely.
going to get very snipey here. I have a feeling he's going to get more and more contentious.
Which were the emails that started off with is it DeRiker?
And going better than it was on Thursday and
DeRiker.
Friday, Malcolm. At least with
Do
Cross.
you need to see that in order to?
I would like to see that.
Okay,
yes, please.
Your Honor, may I put it up on the screen, what's been admitted?
Sure, I'm sorry, what exhibit number is it?
This is gonna be number 155.
He's protected from civil liability, but not
We just
criminal.
need to-
Okay.
I think she's going to build him up on his credentials and then say, "Well, why
Okay,
could
so number
you
155,
not predict this then, sir?"
Do you
I think that's
recall
where she's going with
seeing
this.
I'm curious to see where this goes.
this exhibit when Mr. Keast was speaking with you?
Yes, he showed the bottom email portion.
Okay, and the bottom email is from
Everyone
May
say hi to
13th
Freeney
of
Owen, by the way.
2021, correct?
That is correct.
And the issue on this day was a teacher wanted you to speak to Mrs. Crumbley's son to see how he's doing because he was failing class and trying to sleep all the time, correct?
Yes, it states he is failing my class and tries to sleep all the time.
Now, on this issue, on May 13th of 2021, I may have missed it. You don't recall meeting with Mrs. Crumbley's son to see what was going on, do you?
I do not have memory of this meeting.
Do you not have memory of the meeting, or did you not meet with him? Do you even know?
I do not have memory of the meeting. Evidence that has been researched suggests that I did meet with him.
At that time, in May of 2021, you did not call Mrs. Crumbley to discuss this falling asleep and failing a class, correct?
To my memory, I did not.
Thank you. I'm going to go to the next exhibit, which is number 156. Okay, and it's popping up on the screen. So number 156, this is from September of 2021. So a couple of months later, correct?
Yes, and the next school year.
Oh, that's what I was going to say. So the May would have been the end of one school year, and September would be the beginning of the next school year.
Yes.
Okay, in September, on September 8th of 2021 specifically, the Spanish teacher asked you to check in with Mrs. Crumbley's son because he had written a poem that said he felt terrible that his family is a mistake, correct?
Yes, that is what she wrote in the email.
Now, on this occasion, in September of 2021, did you speak with Mrs. Crumbley's son?
No.
You did not. Okay, so then it would also be fair to say that you did not call Mrs. Crumbley herself and let her know that this concern had taken place.
Yes, as I stated earlier, I followed through with the teacher on
Okay,
this concern, and she gave me further clarification of what had occurred.
okay, so at the end of the day, after further clarification, all said and done, this September 8th date, you did not place a phone call to Mrs. Crumbley.
Correct.
You did not email her or, I suppose, communicate with her in any way, correct?
That is correct.
I'm going a couple months later, we saw exhibit 157, and I'm gonna go ahead and put that up on the screen. Now, 157 is the emails dated, it looks like November 10th of 2021. This was an email from the Spanish teacher to you indicating that Mrs. Crumbley's son is having a rough time and may need to speak with you, correct?
Yes, that she writes he is having a rough time right now. He might need to speak with you.
And on this occasion, you did speak with Mrs. Crumbley's son, correct?
I did.
This was the occasion where you saw him in the hallway and had a conversation with him, correct?
Yes, I caught him during passing time where there were a couple of minutes in between classes and let him know that if he needed someone to talk to, that I would be there.
Okay, so you talked to him, offered support, let him know where he could find you, correct?
Correct.
Now, on this occasion, in November 10th of 2021, after speaking with Mrs. Crumbley's son, you did not call Mrs. Crumbley, correct?
I did not.
You did not email Mrs. Crumbley about what took place with her son, correct?
I did not contact her in any way based on this email.
More creepy vibes than the ATF dude.
Now I'm going to go to
This guy's creepy.
November 29th of 2021. This was admitted as People's Exhibit 158.
If you want to hear how
Yeah,
serious
on
the
the
school was
screen.
taking this,
And this
listen to the voice message that I posted as a standalone video. It's in the playlist.
appears to be an email chain between you and Mrs. Cabina. Is that correct?
Yes, she sent me, this is actually just saying that she forwarded the message. This is not the message.
I apologize. This message, however, that's forwarded makes you aware that Mrs. Crumbley's son was looking at different bullets in his first hour class, correct?
Yes, I do not have that email in front of me right now.
You don't need it. It's on the screen.
So I don't have the exact wording. There it is.
Okay. No, because he was absolutely necessary for the state's case in chief. He was called at the preliminary exam. They've got to call him here. He was not going to be able to wiggle out of this. Maybe a Fifth Amendment plea, but that would be bad. That would be bad. Then all of a sudden, then you got the prosecutor pissed off at you. You don't want that.
He's
sorry,
a key piece of this.
it's too fast
So
for me to scroll
Yeah.
down.
Thank you. Yeah, so it's alerting our dean of students. And
They're trying
Ms.
to set-
Fine,
They're trying to set, this guy's trying to set up the idea that Jennifer knew something was wrong and didn't pull him out of school. And because she didn't pull him out of school, she neglected her duty. That's what they're trying to do.
there's no duty to pull the kid out of the school if you don't require them to pull the kid out of the school.
Right. And if it's suicidal
It's-
as opposed to homicidal, then you want him around people. You even said you didn't want him alone. So the parents logically would think, well, I can't take him right now because we got to go to work. He'd be home alone. So he could stay in school with his
Now,
colleagues,
it-
whatever.
if my concerns were significant enough, maybe not like, oh my God, I need to, Baker Act them or involuntarily commit them. It would be, okay, you're going to, like when I was in residential, hey, you're going to work with me today. I'm going to have you do some stuff for me so I can keep them busy and keep them, engaged and stuff like that. So I don't need to necessarily babysit them, but, hey, I need you to do this for me. Can you help me with this? Make them feel appreciated and wanted, and be surprised how that will actually help out in the moment. And
Right.
so the counselor could have kept him in the office with him all day if necessary, but
Could have.
he didn't.
There was a student in first hour who was on his phone looking at different bullets at the end of the hour.
Now, on this date, on November 29th, 2021, you did witness Miss Fine leaving a voicemail, letting Mrs.
Yeah,
Crumbley know
I don't know a lot
what
about the
happened,
case, so I'll take your
correct?
word for it.
That is correct. I witnessed Ms. Fine
Correct,
calling Ms. Crumbley and then leaving a voicemail regarding a conversation that happened during school.
And this jury has already heard the voicemail. We can agree that there is no request by Ms. Fine or the school that Mrs. Crumbley return the call, correct?
I don't remember the voicemail because I have not listened to it. It would not be odd to me if there was a request or not a request.
Thank you. Now,
For the record, there was not a
that
request.
voicemail, I'm sorry, I'm not going to ask you about the voicemail. At the time of this issue of looking at bullets, you and Pamela Fine discussed this issue, correct?
What do you mean by discussed? I'm not sure I understand.
I'm assuming and asking, did you and Ms. Fine discuss the fact that Mrs. Crumbley's son was looking up bullets?
Are you asking in reference before the student arrived?
Yes, before or when the student arrived, either.
There was not much time between me getting there and the student arriving. The context of the meeting was largely led by Ms. Fine to gain an understanding from the student's perspective of what was going on at the end of the hour. First, to see if he was going to be forthcoming with the truth, and then to see what was actually going on and what his reasons for doing so were.
And when you guys spoke with him about the bullets, there was also discussion about other things people may look up on the internet that are not illegal, but just not appropriate during school hours, correct?
There was discussion about school appropriate behavior, yes.
And overall, Mrs. Crumbley's son was told looking at bullets, not appropriate for school, correct?
Yes, looking at bullets is not appropriate during school.
And beyond that, there was no further disciplinary action taken by the school, other than
I
just a
technically disagree with that
notification phone
statement.
call.
What was that?
I'm gonna technically disagree with the idea that looking at bullets during school hours is inappropriate. There's 100 reasons you could do it, for assignments, for other things. Like, I mean, probably not nowadays, but history stuff, researching World War stuff, weapons. There's reasons you could be looking it up. Maybe not on your
That's
personal
true.
device,
No.
but
Yeah, no, that's very true. I think it was probably the issue is that it's not school related, it's not for an assignment, and he's doing it on a personal device. They're probably the two bigger issues, and that's probably why they said, it's just inappropriate. I think their school is just CYAing itself all over the place.
It is,
they're looking at
because
bullets. Let's send them down to the classroom, or let's send them down to the office rather.
this is the same kind of crap that, like someone was saying in the chat, is after the 13 Reasons Why thing came out, suicide was being talked about. Doesn't necessarily mean that people were suicidal, but people were being punished for just talking about it. All just across the board. You mention it, you're being kicked out of school until you see a professional. That doesn't help anybody. That hurts more people than it helps, and it puts a very strong disdain in for the administration. And so no one's going to cooperate with the school after that if they've been punished by that. I was suspended for 10 days in 7th grade for getting into a fight that I didn't start. But
I was
got my ass.
suspended in 8th grade because I threw a paintball hand grenade in the girls' locker room. Today, I'd be charged with a crime.
That's so based.
Voicemail to Mrs. Crumbley.
To my knowledge, but I would not be the one making the disciplinary decisions.
As far as you know, though, that was the end of it.
That was the end of my involvement in it.
Okay. Now I'm going to turn to Exhibit 159. This was admitted when you testified, and this is an email that appears to be between Allison Karpinski, and this was sent to you by Ms. Karpinski. Do you recall this email?
I do.
Now, this email is dated on November 30th, 2021.
Yes.
Correct. And no, we agree, November 30th, 2021 is the day that ultimately becomes the shooting, the day of the shooting.
Yes.
And this email was sent at 8:05 a.m. by the teacher to you.
Yes.
And specifically mentions that Mrs. Crumbley's son was watching videos on his phone of a guy gunning down people, correct?
It says that today he is watching videos of his phone of a guy gunning down people, and to continue, she writes, it looks like a movie scene and not security footage / a real event.
Okay, so she represented that it looked like a movie scene. It doesn't look like a real event. Okay, but she mentioned that it's definitely still concerning, correct?
Yeah, she says when taking into account some of his other behaviors, that she found it definitely still concerning.
Now, when did you become aware that Mrs. Crumbley's son was watching these concerning videos?
When I read the email.
At 8:05 in the morning?
I did not read the email at 8:05. I believe I read it approximately 30 minutes later.
Okay, so you would have read this email at approximately 8:30 that morning.
Around that time, yes.
Now, when you read the email at 8:30 that morning, you did not call Mrs. Crumbley's son down to the office to ask him about these videos, correct?
I was on the phone at the time with other parents.
So you did not call Mrs. Crumbley's son down to ask him about the videos. That's fair, correct?
I did as soon as I was able to.
Okay, so there's a time lapse between when you got the email and when you were able to speak
I like that.
with Mrs. Crumbley's son.
Didn't do it immediately. Neither
Now,
did the mother.
when you spoke to Mrs. Crumbley's son, you did not ask him to bring up the videos and let you watch what he was watching, correct?
Correct. I asked him what he was watching.
And you relied on the information he provided to you about what he was watching.
Exactly as I would if I asked him to show me the videos.
That's
yes.
not the question.
I'm sorry, I don't understand what that means.
I was relying on him to provide the information, which would be the same as if I had asked him to show the videos.
No, it's
Okay,
not.
but if
It's
you
not.
saw the videos, you would know specifically what they look like. You are instead relying on what Mrs. Crumbley's son says was on the videos, correct?
Yes, I asked him what they were and he told me what they were. And I relied on the information.
I know. I feel like a student might lie. So maybe you want to ask to see them if you are concerned. I don't know. Just a
Hey,
thought.
I'm going to tell you something really cool that no one knows about, right? So
Yeah,
this is a secret in the mental health field. Teenagers lie.
Well, I have never heard this before. I often suspected, but I'm glad that someone has finally confirmed my suspicion.
I'm happy to be the first person to say this out loud.
Gave me.
When he told you what the videos were, the information you relied on, did he tell you where he obtained those videos from?
No.
Do you have any idea, or did you ask how long he was looking at those videos for?
I did not.
Now, on November 30th, so about an hour after the time period we just discussed, that was when Miss Morgan made you aware of this math paper that we've discussed extensively in this trial, correct?
Ms. Morgan did not make me aware of the math paper. She made Mr. Ejak aware of the math paper.
I apologize, and then was it Mr. Ejak that made you aware of it?
Yes.
Okay, thank you, and thank you for clearing that up. Now, your testimony, you testified about the math paperwork, your observations, your thoughts about it on a couple of occasions over the last couple of years. Is that a fair statement?
Yes.
And when you saw the original photograph or the original math paper, we can agree that there is a gun drawn on the math paper.
Which one are you referring to as the original?
I'm speaking about the one, let me put it up on the screen. It would be, it's within Exhibit 160. And it's the prior to alterations, the math paper.
So
Do you
this is
recall
the
seeing
one
this?
prior to the alterations.
Yes, I was sent this in an email approximately 30 minutes into our meeting.
Okay, now when you saw, did you see the altered math test first, or did you see I called this the original. There's also one, because
The original.
let's just be clear here. The shooter drew on a math paper, and what we see on the screen is that original drawing and writings. Is that correct?
What you see here is the photograph taken by the math teacher.
Of the original paper.
As it was when she had it, yes.
And then after she had it, the shooter wrote more on the paper And we ended up with a second math paper that is essentially the original math paper plus some writings on it, correct?
Well, it's doctored.
Doctored, okay, right, so I'm gonna call this the original, and then I'm gonna call the other one with the additional writing, the altered version. Is that okay with you?
Understood.
Okay, for the purpose of questioning. Okay, now, I'm gonna open up the altered version as well, which was admitted as Exhibit 123, okay? So it's fair to say that you are familiar
I'm removing
both
your
with,
text or your chat.
with the original math paper and with the altered one, correct?
I was able to look at both of them over the course of our meeting, correct?
And when you look at both papers, it's very clear that Mrs. Crumbley's son drew a picture depicting a gun, correct?
Yes, and the one especially that has no scribbles over it, I would not say that without context that it would be very clear on the altered one that that is a gun. Without context of the original.
Okay, I agree with you. So you're saying that the first photo on the left of the screen, it's clearly a gun, but when he altered the drawing, he crossed it off so much you might not know that had been a gun drawn there.
Correct.
Okay.
I think it's a pretty decent drawing of a gun.
Drawn on the sheet.
There's a better picture of it, but
it's not bad.
That gun,
no, I know.
even just seeing the gun, that was not enough to make you believe that Mrs. Crumbley's son posed a risk to himself or other students, correct?
Get him, boy. Get him.
I
girl.
wasn't sure whether he posed a risk to himself. So that is why I called in the parents.
Okay.
I was concerned, and I wouldn't call in parents unless I was concerned.
Okay, so you called the parents in because you were concerned, but we can agree that seeing the drawings, just the drawings alone were not enough for you to conclude there is something dangerous to other people.
When I take that in context, that is only a piece of the information I had. I also was looking at his demeanor throughout it. I also was asking questions to him, asking if he was a threat to himself or others, and taking his response of sadness, which is not a common threatening response.
Okay.
It's referred to as a math paper because it was in math class, and you could see that it's actually a math worksheet that he was drawing on. And it was his math teacher that first noticed it. So that's why it's called the math paper. That's what it's referred to. And this is the original, and this is the altered, doctored, second version, whatever you want to say. But that's why it's called the math sheet.
And it's, in all fairness, and you've had lots of training on this, correct?
I have had.
I don't know if you want to harp,
been...
like for Cross, I don't know if you want to harp so much on this because he already said that he was concerned about self-deletion and nothing else. So why make it about, well, could he be a danger to others? No. We don't. Why do we care? This is the trained expert. We've gone through his credentials. He was concerned about self-deletion, not harm to others. Let it be. So if the trained expert's not concerned about that, then why are we going to dive into the possibility that he could be dangerous to others? I'm thinking she's stepping a little too far. She asks like one too many questions, I feel.
Trained, you've been formally trained on how to assess this kind of information and how to deal with it, correct?
Correct. And the number one way that I would be dealing with it would be to entrust the care to parents.
To entrust the parents with the care of their child.
Correct.
Okay. So
I don't think he answered any of the math questions.
There was.
I was thinking the only thing that would be worse is if it was calculating trajectories.
The materials from this case
right?
about a step 1, step 2, step 3 Do you know what I'm talking about in terms of evaluating a suicide risk?
I don't know what direct thing you're referring to.
Okay, are there certain steps, if you do have concern, that you follow if a student is exhibiting what you called suicide ideation?
I think she's getting there.
Ideation is very different than actively suicidal.
Okay.
So I wonder if what you're describing might be an active suicide checklist as opposed to what we
I'm gonna leave Ken in charge for a minute. I'll be right back.
Well, what do you do if you?
This
you
is
said
my
in this
stream
case
now.
You were concerned about suicidal ideation, correct?
Yes.
So what do you do when it's a concern of suicidal ideation?
I call the parents.
Call the parents. Okay, and that's what you did, obviously, in this case.
Yes.
Okay, and one of the questions I do have for you, and I'm just going to page 72 from the civil deposition. This is just for you guys. Page 72 of the civil deposition is where I'm getting this question from. A drawing of somebody who is shooting a gun is just a drawing. That is something you've said before, correct?
I do not remember.
If there's not another person in the drawing, that's of significance to you when you see a picture of a gun, correct?
Are you referencing in regards to the math assignment?
Yes.
In the math assignment, if I see multiple people, I do have a different level of concern.
Okay, so explain for us then what, and I don't know why that clicked off, but it's gonna pop back up. So explain to us what you mean by when you see another person or you don't see another person. Tell us what you see up here and how things would change if there were multiple people.
Well,
I said a bunch of
see one
racist things while you were
If
gone.
I
so-
see somebody holding
Okay,
a gun
that
in one
happens.
body, my response is completely different.
Okay, so, and have you had training about looking at drawings by students and being able to take them into account when you're assessing situations?
I've had training in how to assess situations. I would not say I've had training in students' drawings.
Okay, but your conclusion was that because there's not a second person, seeing a gun on these pages in and of itself alone would not be enough to cause you concern.
Again, you're taking a very small piece of that. That is just a piece of what I saw in totality.
Okay, so you were asked before, you didn't see anything that suggested that there was a gun in the hand on this drawing, and your answer was no, correct?
In regards to this drawing,
Yes.
I do not see a gun in someone's hand on this drawing.
Okay, you were asked, that's a pretty important thing for you to know or not. Do you agree? Your answer was a drawing of somebody who is shooting a gun.
Poll going up regarding the
Still,
council's
there's not
testimony.
another person. It's just a drawing. Do you recall testifying that way when you were previously asked about this drawing?
That was not in regards to this drawing.
It's fair to say that, which drawing was it in regards to then?
Not this one.
So you testified at a deposition on September 14th of 2022, correct?
I believe that was the date, correct?
And there are, the discussion prior to those questions was about the drawing in class that day. And
I'll just bring it up on screen. Ken and I were talking in the back. It seems like the defense counsel might be asking questions she doesn't know the answers to, which is never a good approach when you're asking questions, especially on cross. However,
that's the impression I was getting.
if you do it right, though, you could ask a question in a way where it doesn't matter what the answer is. You can just spin it one way or the other. But I don't feel like she's got the ability to spin. Like I said, with the whole self-deletion argument, just leave it there. Don't go into the potential to unalive others sort of thing. She asks just like one too many questions or two too many questions.
I feel like this is a key witness for her, and she didn't do like the research on the the counselors, like education requirements, or none of the things that, because I could tear him apart easily, and I'm not even a lawyer.
Yeah,
And
yeah,
it's just not there, and I think it's a big part that she's missing.
yeah. It's her style mainly, more so than anything. I mean, I like the points she's getting across. I'm not a fan of her style, but hopefully it's resonating with the jury.
Yeah,
I'm
that's all
actually
that
gonna
matters at the end.
The drawing
Yeah,
being
I'm
on the
going to email a
violent side, do
reporter
you
that I know is
recall
in the
that?
courtroom just to see if she
In
has some
regards to
insight on
the
the jury's
email from the
response.
teacher that we discussed earlier,
Cool.
yes.
Okay, so at the end of the day, your prior testimony that seeing a drawing of a gun, that in and of itself, by itself, does not create enough of a concern that something more sinister is happening, correct?
We are looking at a total picture and not just a piece of a picture.
And you are trained to look at that total picture, correct?
I took the approach to look at the total picture.
In addition to looking at the total picture, and by picture, I'm saying the picture that was drawn, you also look at the picture in terms of the demeanor of the person you're speaking to, the way the person is presenting, the way the student is behaving, a number of factors, correct?
I try to take in as much information as I can.
And taking in as much information as you can is certainly something that you have learned to do through, in addition to your training, your experience, correct?
Yes.
This is not the first time that you're calling a student down to your office to talk to them about something that may be problematic, correct?
Well, and that's why I was not the only one in the meeting. Was I didn't want to take the approach of I was the only one making the call. I also had our person in charge of discipline.
Well, she's not wet behind her
And
ears,
when
but I don't
you-
know her
So you are in the
level
meeting,
of
and when
trial
you're saying the
experience.
person in charge of discipline, you're talking about Mr. Ejak, correct?
Yes.
And Mr. Ejak is going to testify, but your understanding is that Mr. Ejak has also had training on dealing with these kind of situations, correct?
I do not know his total background.
You would assume that as the assistant dean of school of the school,
I'm just
he's got
objecting to
training.
the question of this witness. Mr. Ejak will testify. It's appropriate for him.
I'll withdraw the question, Your Honor.
Yeah, he can answer that. Mr. Ejak.
Don't withdraw the question. Don't
Now,
voluntarily
when you
give up your
asked,
hand, or your position, rather.
Mrs. Crumbley's son about the videos he was watching, he indicated to you that he wanted to be a video game
I will agree,
designer,
Sean.
correct?
He did.
And he actually had a detailed conversation with you about an opportunity that Oxford has for students to get training to become video game designers, correct?
I showed him a program through Oakland Schools that could lead him into that area.
Okay, so you and Mrs. Crumbley's son had a conversation about if he was interested in pursuing a video game designer career. The school system even has opportunities for him to further that interest.
Yes.
And in that conversation, when you were speaking to Mrs. Crumbley's son, you believed he had a genuine interest in this video game designing future.
Yes, I did.
What? Why was he yelling?
If you believed that Mrs. Crumbley's son did not have a genuine interest in becoming a designer, or that he really was drawing pictures with a plan to hurt people, you would have certainly taken different actions, correct?
If I believed that he was a threat to people, I would have taken different actions.
Yeah, just so everyone knows, the prosecutor, Kerry McDonald, is a former Oakland County judge and former colleague of the judge that's currently sitting on this case. There's no juicy details about it, other than the fact that sometimes when they go back and forth, like you saw last week on Thursday and Friday, I feel like they were almost talking like colleague to colleague, as opposed to attorney to judge. That's the only bit that I really picked up on. But yeah, she is a former judge in this county.
Is there bias that could come from that? Like, I doubt there's like reversible error bias, but
No, because I don't know their dynamics, but like I was for the longest time a member of the Oakland County Bar Association. So me as a criminal defense attorney, I would go have social events with all these judges and prosecutors and stuff too. That doesn't create a bias. I practice regularly in front of judges. I'm the president of a bar association now. And, you know, when I call the judge sometimes about a case or try to schedule stuff, sometimes they're like, oh, when's the Christmas party happening? You know, it's just, it is what it is. We're all colleagues here. So
Yeah, that's understandable.
There's no real bias, as long as it's not, as long as they're not like business partners. If they were like, if they had a firm together at some point in the past, then there could be some conflict or something. But just
I
because
just
they
think
were
that
both judges.
going from judge back to prosecutor, though, I don't think you do that without either being forced to or having a really damn good reason to do so.
I know, that's what I don't know the reason why she left the bench. I honestly, I don't know. It was before I was like paying attention to anything. And she
Yeah.
ran for prosecutor like 4 years ago. Yeah, I don't know why she left the bench. I don't know if it was a personal decision, if she was like, you know what, I just want to be back trying cases again, so I'll run for prosecutor. I have no idea. It could be something as simple as that to, for some
Yeah.
reason, she was kicked off the bench or whatever. I honestly, I don't know. I don't
Not
wanna
trying to
speculate.
assume malice or anything.
Yeah. But you could just tell, like when they have an exchange, like when the judge was scolding the prosecutor about the emotion thing. She's like, I didn't say that the defendant or no one could show emotions. And then Karen came back and it's like, Your Honor, I know how to read your orders. And she's like, well, let me tell you that it doesn't say not show emotions, is don't emote, don't, you know, sigh and grimace and things like that. Why won't they say Ethan? There was a pretrial ruling not to use Ethan's name. I don't know the reason why. We can speculate all we want, but they are to identify him as the defendant's son or the shooter, and not use his name. I think the underlying reason is because he's a minor, but I don't think that really justifies it. Plus, we're just, you know, it's everyone knows what we're talking about, so it doesn't really matter at the end of the day. And I know we're behind, but we'll get caught up on a break, guys.
You testified about when the parents came in and this meeting that you had with them. You obviously recall that, correct?
I do recall the meeting.
I don't want to play this at
When you met
1.25
with
because
the
it's important.
parents, they were present for approximately 12 minutes out of the entire time you spent with Mrs. Crumbley's son.
Yes.
Ooh.
And you testified that you were with Mrs. Crumbley's son for approximately an hour and a half, correct?
Correct.
So it would have been an hour and a half, including those 12 minutes.
Yes.
Now, prior to that hour and a half spent with Mrs. Crumbley's son, you had never spent any kind of time really, aside from short conversations with Mrs. Crumbley's son, correct?
Correct.
And you also had never spent time with Mr. or Mrs. Crumbley talking to them about or handling matters regarding their son, correct?
Correct.
Okay, so it sounds like, so she was first elected as judge, Karen McDonald, in 2012. She was reelected in 2018. A year later, in 2019, she gave up her seat to run for prosecutor because she believed that she could be have a greater impact on her community. So that's what it says. So it says
So
she gave
she-
up her seat only a year into her second tenure
As judge?
as judge. Yeah, she gave up her seat and ran for prosecutor. So it doesn't look like there was any disciplinary issues or anything like that. She just gave it up.
Okay.
So sounds like a personal choice. I would hate to be a judge personally, so I'm right there with her. I don't want to.
Why is that, if I may ask?
Well, I don't want to be a judge mainly because I'd be tied down to a particular thing. Like, you have rules to follow. You have, first of all, you're a politician, so you got to be, you know, I'm squeaky clean, right? But then on top of it, you are like, anything you do is then measured against what you do on the bench. And anything you say, like I'm friends with some judges and they don't have Facebook accounts and they don't do social media. And when they're out in public, they're very careful to watch what they say and do. And I wouldn't want to live that way to begin with. Secondly, I don't want to sit in a courtroom from 8:30 a.m. till 5 p.m. Monday through Friday. I just don't want to do that. I like the courtroom. I like trials, but I don't want to sit there. Also, I was a judge. I was a judge for some mock trials. I do it almost every year. I do these mock trial things that I'm a judge for. And oh my God, is it nerve-wracking when someone's like, objection, and you're like, oh my God, do I sustain or do I, you know, it's nerve-wracking to watch trials. And so for a number of reasons, I don't want to be a judge. And I'm definitely not squeaky clean. I don't know if I'd ever get elected or appointed. I don't want to play the political game to get appointed either. So
when Mr. and Mrs. Crumbley arrived at the school and were communicating with you on this issue, these are not parents that you're seeing on a weekly or even monthly basis, correct?
Correct.
I imagine at the school there are other situations where you have students that are essentially frequent
That might be
flyers
it,
down
too.
to your office, correct?
I do know some students more than others.
And some of the students that you deal with more frequently, you're also used to dealing with their parents on a more frequent basis, correct?
Potentially correct.
And the more times you have to deal with the parents and the more times you have to deal with their child, the more you get to know about the family and the dynamics of the relationships, correct?
Yes, I would hope the more time I spend with someone, the better I know them.
So when you are talking about how the Crumbleys greeted their son or did not hug their son, it's fair to say that you are not aware, you've never really seen the Crumbleys greet their son on other occasions, correct?
Correct. I'm not making a judgment on normal. I'm simply stating what happened.
Okay, and that's completely fair. And I just want to confirm, though, that in terms of when you're making the observation, there was no hug or a certain kind of greeting. You also haven't had the experience of seeing the Crumbleys greet their son on other occasions.
that's not bad.
And it's also fair to say that when parents come into the office, parents may have a different reaction about their child being down in the counselor's office or in the principal's
Hey, Joe, don't
office.
ask me about Bundy.
Correct?
Well, first
Judge
I would say
Bundy.
those are two very different places.
That's an
Okay.
off the stream
No, you
conversation.
don't expect all parents to respond in the same way.
No, I
You
do
get
know.
parents who are angry at their child as they're walking in the door, right?
Rarely.
Some people are coming in and have more of an anxious look.
They could.
Some parents may come in and just seem like this is no big deal.
Again, all parents could respond differently.
Okay, so there's any number of responses, and in the end, and if your training says any different, let me know. There is no right answer about specifically how a parent should respond to going to a school counselor's office or going to a school principal's office.
Yes, again, I stated I'm not making a judgment. I'm simply stating what happened.
Thank you.
That was not bad. Kind of hit the point there and moved on. I like that.
Yeah, it wasn't bad.
Now, the dates that we talked about are dates where obviously through the course of this investigation, you identified emails where you were involved with Mrs. Crumbley's son. Is that a fair statement?
I'm not sure what your question is.
Did you provide
I was
the
just messing with you. Hey,
emails
Joe.
that we talked about and that were admitted as exhibits?
Did I provide them? The Oakland County Sheriff's Department had full access to my email.
Okay, did you at any point go through your emails to take a look at any emails related to Mrs. Crumbley's son?
On the night of the shooting, I did, with a police officer, go through and search for anything I could think of from that day and print and hand them to him.
Okay, and then ultimately, any of these other emails we've seen were discovered by law enforcement.
Yes, there's been a full cooperation with that.
Okay, and I'm not trying to allege you haven't been cooperative. I'm just asking that those emails obviously. I imagine all your emails are stored on some kind of a system. Would that be?
Not my area.
Not mine either. This jury learned about my technology abilities on
Oh my
Friday.
God.
I want to just turn your attention to a couple of dates. On March 8th and March 9th of 2021, you didn't have any experiences with Mrs. Crumbley's son related to needing counseling or being called down to the principal's office, correct?
I don't remember it.
Okay. On March 16th, which was a Tuesday, March 17th, Wednesday, 18th, or 19th, you don't have any incidents on those dates with regard to Mrs. Crumbley's son either.
I don't remember any.
Okay, if there had been incidents involving Mrs. Crumbley's son on these specific dates, would you assume they would have been included in the emails of all the other dates that were included about?
If there were emails of them, they would have been included.
Okay, so we don't have any emails of March 16th, 17th, 18th, or 19th, correct?
To my knowledge, no.
We didn't see any emails or concerns that arose from, well, this is a Saturday, so probably not likely, Saturday, March 20th, correct?
I don't know of any.
Sunday, April 4th,
I don't know of any.
not even the next day, Monday, April 5th?
I don't know of any other meetings aside from the emails that have already been presented.
Okay, so then in all fairness, when I'm April 29th and November 4th, same thing, you don't have any awareness of any of these dates?
I don't know of anything specific towards those days.
Okay.
So he's unaware of any meetings with the parents except for November 30th, right? That's what he was getting at?
Now,
Just
you testified
I think so.
that it's
Yeah,
your
that's what I got.
hope that Mr. and Mrs. Crumbley would take their son home and get him into a counselor that day, correct?
Yes,
When you had that hope, you gave them a list of counselors to suggest they call and noting which ones took various insurance programs, correct?
yes, I provided a list of resources.
Now, in terms of getting a counseling appointment within one day, you don't have any knowledge if those counselors on that list could guarantee a same-day appointment, correct?
Thank you.
I don't know counselor schedules and I can't speculate on what they would have had.
Is it
That's a
fair to
BS
say that
answer.
in the post-COVID
Wiggled out of that.
time of 2021,
He'll know unless they're in a
mental
crisis
health
center.
services have become more difficult to obtain appointments? And if you don't know and you're not the right person to ask, just let me know.
I don't work in community mental health, so I can't.
Oh my God.
Have you personally had to call to schedule therapy type appointments for anyone?
I experienced a shooting. I called to cancel.
Oh my
to
God.
therapy
No,
for
that's not what they're
myself.
talking about. Oh my God.
Okay,
Ask, have you ever recommended a student and then followed up with them? How long did it take them to get in?
and when you called to get therapy for yourself, it was obviously a very, very urgent situation.
I mean, it was a pretty impactful situation, yes.
Okay, and did you end up seeing a counselor on the 30th?
No, I was cooperating with law enforcement and still in our building on the 30th.
Okay, so your appointment was sometime after the 30th, correct?
It was after the 30th.
And sometimes when you call to get a counseling appointment, it's not unusual to have to wait a couple of days or to schedule it, correct?
I think we're getting a little hypothetical with this, and I can't speculate on what's usual or not for
That's why
counselors.
she needs to ask about
That's fair
prior
enough. I appreciate
events, prior referrals with prior turnaround time. Because then it's not a hypothetical. Ask it. Come on. get there.
When you were speaking with Mrs. Crumbley's son, it's fair to say that you and Mrs. Crumbley's son discussed whether he wanted to stay in school that day or go home prior to the arrival of Mr. and Mrs. Crumbley. Is that correct?
That did come up, yes.
And Mrs. Crumbley's son's position was, I want to stay in school, correct?
Correct.
COVID had been hard on him. He didn't like virtual learning. Was that your understanding?
He did state those two things, yes.
And there was discussion when the parents arrived that missing school is a source of anxiety for Mrs. Crumbley's son. Do you recall that?
I do.
So before Mr. and Mrs. Crumbley even got there, the option for Mrs. Crumbley's son to stay in school was on the table.
Well, the option,
here we
there
go.
is no option of staying in school. School is a requirement unless you meet
Oh, that's
your
bullshit.
condition, which is no longer
Yeah.
available.
That's
That's
fucking bull.
yes.
Oh.
Okay,
Follow up.
if a child gets sick at school, at Oxford High School, and vomits, okay? Are they allowed to stay in school the rest of the day?
I don't
Yeah,
know.
they have
That's
to.
not
They're
something
required.
I deal with.
We just
Are
said
you
they're
aware
required.
if a child has a temperature, if they are allowed to stay in school? And if you're not aware, let me know.
If they have the
allowed to
bubonic
stay
plague,
in
can they
school,
stay in
Yes.
school?
if we didn't, like, again, hypothetical, but not my area, I don't send students home.
Oh my
Okay,
God.
are you aware if the school will tell parents, you need to take this child home if they are sick at school, physically sick?
The only time I remember that being a discussion was during COVID.
Okay, during COVID.
Oh no.
Were
Bull. Oh my.
kids
Ugh.
who were exposed to COVID allowed to be in school?
No, because we were
I'm
following
trying
not to
rules and
slam-
regulations outside.
Try not to hit my desk.
So even if parents said, I want my child to be in school, he has COVID, but I want him to be there, that's not allowed, right?
Judge, I have to object to relevance now. We're awfully far from
Well,
Relevant.
He said that that's not up to him. That's maybe,
Correct.
is that up to like the school nurse?
Are you
There
aware
is no
of
school
any?
nurse. The COVID tracing.
Okay, so this is, first of all, no question is posed of you, sir. So shut the hell up. Secondly, are you aware of any situation in which a child was sent home from school for a non-disciplinary reason? Are you aware of it ever? Right? Let's start with that, and then let's narrow it down. Okay, what was the occasion? Oh, that wasn't disciplinary? Okay, so it can be done, right? It's just, I'm getting frustrated with this defense.
Oh no, it is because he's absolutely avoiding the question because he knows if he says, because for example, if a child was actively suicidal, no, they have to stay in school. Literally ask that question. That's like if there was a kid saying they wanted to kill themselves, would you let them stay in school? Like just straight up said, I want to kill myself. Would you let them stay in school?
Yeah,
It's an obvious no. They need to go get help. Like
well,
they
that's
can
a
leave.
hypothetical. We can't answer a hypothetical. But you
Don't-
don't need a hypothetical. You can use real world examples. So,
Yeah.
right, he doesn't want to answer a hypothetical. The judge is going to make him fine. Use real world examples. You can get around this.
Was not through the school, that was through the county health department.
All I'm asking is, there are times where if a child is sick, it's not an option for them to be present in school.
When the county health department regulated that.
No.
yes.
No.
And you testified that if there had been a discipline issue as to Mrs. Crumbley's son, that may have been grounds to make him have to go home that day, correct?
That could be the case depending on the discipline issue.
And in terms
Doesn't
of the
require
discipline
discipline.
issue, I realize you're not the discipline
Squeeze it harder.
person,
Squeeze it harder.
but the school has the option, depending
Best
on
Christmas gift I got.
what's correct. They could suspend a student, they could expel a student. There's processes over school discipline, correct?
There is a process. I am not a part of that process.
It's your testimony, though, that in this case, the school did not find a discipline issue with respect to to Mrs. Crumbley's son.
That is correct. There was nothing that was determined as a discipline issue.
So it was not a discipline issue that he was looking up bullets on his cell phone during a class.
I would not be the one making that determination.
In this case, that was not
Has
something
a
he was
student ever been
disciplined
disciplined for something that they were looking up on their phone? You know, you can go to real world examples. In your experience, are you aware of any time?
Yeah, she's just dragging this out.
She's just not asking the right questions. In this,
That too.
maybe it's just style. I don't know, but I feel
Yeah.
like it's frustrating me.
I already stated I was not a part of any potential disciplines. To my knowledge, no.
Same thing with watching videos on a phone. The school did not make a discipline issue that would cause Mrs. Crumbley's son to go home for sitting and watching videos on his phone during class, correct?
There was nothing that was determined to be a discipline issue.
And Mrs. Crumbley's son sitting and drawing on math paper instead of actually doing the math paper he's supposed to be doing.
I know. I want
As
to.
far as you're aware, the school also didn't find there to be a disciplinary violation for that.
Judge, Mr. Housman already testified that discipline is in this area. That's Mr. Ejak's area.
See, this is the thing, right? I'm not frustrated with the witness. The witness is doing his job. I'm
Yeah.
frustrated with the attorney because the attorney should be able to get around this witness answering those questions and those objections. Because
He's
disciplinary
not
is
that
not his
smart.
He's not. Are you aware of, right? Are you aware of any time when a student was sent home for a non-disciplinary issue? Yes, I am aware of such a situation. Great. What was it that caused this person to be sent home? It doesn't even matter what the answer is. Okay, now we have a non-disciplinary reason to send somebody home. And it doesn't matter if this is disciplinary or not. We know that the school has that ability.
I have a phone call taking me once.
Sure.
He doesn't make that determination, he said.
I'll ask Mr. Ejak then when he testifies. Now, you did testify that one important thing was that you did not want Mrs. Crumbley's son to be alone.
Sorry, Farrell, I'm going to put, okay, so then he says he's not aware of it. Okay, so your job as a counselor is to counsel students, right? And you're telling me that in your umpteen years of counseling students, counseling student means making sure that they're staying on top of things, that they don't have any behavioral issues, that they're not overly sad, whatever it may be. You're telling me that in your years of doing this, you are unaware of one single situation in which one of your students was sent home on a non-disciplinary reason for illness, for any reason whatsoever. That's what you're telling me. And if he says, yes, that's what I'm telling you, then he's a liar. And the jury sees that he's a liar. So
To be alone after you thought he was so sad and experiencing so much sadness, correct?
I didn't hire me,
I
Farrell.
feel that it was wise for a student with signs that could be suicidal ideation and things that I saw as suicidal ideation to be alone.
Now, when you spoke to Mrs. Crumbley's son, he also wanted to be around other peers that afternoon.
He stated that he wanted to be in school. I don't remember him specifically stating anything about other peers.
Do you recall telling Mr. and Mrs. Crumbley that it would be good for him to be around other peers versus being alone?
I don't remember specifically.
Only it worked that way, Farrell.
Is that something
I'm
that
back
you
now.
believe, or and if you can't answer the question, just please.
Sorry, I
let me
just
know.
ranted a bit.
What is your
It's
question?
fine. Did I miss
My
anything
question
important?
is that something that you
Me
believe? That
saying
it
how I
have been
would do
better for him
things.
to be around peers that afternoon versus being left home alone?
It's the judgment call I made.
I'm sorry, what was that?
That is
He
the
did not
judgment
sound
call I
comfortable
made, was
in
that
his
I
statement
felt it
there.
was better for him
Mhm.
to be around peers and people who are his age than to be home alone.
If I had to guess, he feels
May I have just
responsible
a moment,
personally,
Your
but
Honor?
won't say it out loud. You could just hear it in his voice, the way
I
his
have no
voice
further
broke.
questions. Thank you,
Yeah.
Mr. Hopkins.
Redirect.
Thank
That's
you.
it? Oh my
Mr.
God.
Hopkins, you were asked about the total
I would offer, but no one asks, so
picture by council.
I'm not allowed to ambulance chase.
With you. On November the 30th, when you met with Jennifer Crumbley, did she tell you that on March the 9th of 2021, her son had texted her that he was seeing demons and bowls flying off the shelf?
I did not.
Okay, so I know, did Jennifer
it's the
Crumbley tell you
exact
that on
same
March the
redirect
17th,
as the
her
preliminary,
son had also texted her that he was hallucinating?
No.
like word for
Did Jennifer
word.
Crumbley tell you that on March the 20th, he had texted
I was
his
talking to my
mother?
wife about this earlier, about how
I
it's
would
a
ask
stupid
the
argument.
prosecution staff for leading questions.
Judge, I'm just trying to get through redirect and.
No,
Oh,
that
come
doesn't
on.
matter.
This is
You can't ask
Bullshit.
somebody a
in
question.
response to her.
I don't know how you can ask it another way.
I'm not suggesting.
Don't
the
lead.
answer, Judge, I'm just-
Are you aware of
He's
any
not
other
suggesting the answer.
circumstances
He's
outside of the
suggesting a
school
specific
setting?
question. It's a yes
You're a
or no
prosecutor. It's
question.
an open-ended question. You should fucking know this by now.
He's not suggesting the answer, so.
Thank you.
If you
It very much
Sure.
is
Did
suggesting
Jennifer
the
Crumbley
answer.
tell you that her son texted her on March the 20th, 2021?
Objection. The witness is
No.
testifying.
Did
He's
Jennifer
leading.
Crumbley tell you that in
Or
April of
the
2001,
attorney is
She had told-
testifying.
a friend of hers that she thought Ethan was depressed?
No.
Did Jennifer Crumbley tell you that she had referred to her son as weird?
No.
Did Jennifer Crumbley tell you that she had never once set an appointment with any mental health professional?
No.
Did Jennifer Crumbley ever tell you that his only hobby was involving firearms?
No.
Did Jennifer Crumbley ever tell you that she posted on Instagram as early as June of 2021 that he had obtained his own handgun?
No.
Did Jennifer Crumbley ever tell you that the day before the shooting at 3 o'clock.
Object
in the morning, you
again.
shoot yourself with
Object
research and
again.
clinical research
Leading.
or clinical depression options.
No.
Did Jennifer Crumbley tell you that she and her husband gave her son a 6-hour 9mm handgun just 4 days before the shooting?
No.
Did Jennifer Crumbley ever tell you that on November the 30th, 2021, it wasn't the first time he asked for help?
No.
Did Jennifer Crumbley ever tell you that the gun that he drew on that math worksheet was identical to the 6-hour 9mm handgun that was
Your
used in
Honor,
the shooting?
I
Nice.
object to the prosecution's characterization that that drawing is identical. That's a conclusion that
That's fine.
There
Did
you
Jennifer
go.
Crumbley ever tell you that the day before, on November the 29th, on that Monday, the day before, after the voicemail was left for her from Pam Pine,
The prosecutor does better cross-examination than the defense counsel.
she texted her son and said, "LOL, you have to learn not to get caught."
No.
Did Jennifer Crumbley ever tell you that James Crumbley worked for DoorDash and had no obligation to not take your son home?
No.
Did Jennifer Crumbley tell you that on November the 30th, she was permitted to leave work when she needed for family issues?
No.
Did Jennifer Crumbley tell you that on November the 30th, the meeting that she allegedly had in the afternoon, she was not required to attend?
No.
That doesn't make any difference.
Why-
Jennifer Crumbley
Why
tell
are we
you
not objecting?
ever
These
that
are
their
assuming
son was
facts, not
struggling
evidence.
throughout the year 2021?
She confirmed it based on what he had said in regards to COVID and virtual school.
But they never went through these details.
Not these details, no.
So it took you all about 20 minutes to decide to request Jennifer Crumbley to come into the school immediately. That's what you testified to?
Yes.
Is that the total picture that you wish you had?
No.
Now, what if
What?
Jennifer Crumbley
Okay.
told you all of these things?
That's
I
the
just
total
went
picture
through?
he wished
Your
he
Honor,
didn't have.
objection is to speculation, and hindsight is 2020.
Not
Would you like to
sustained.
have as much information as you possibly could have?
Absolutely.
Was their son still in the room in your office when the defendant said she couldn't take him home?
Yes.
Nothing further.
All right, you can step down. Your excuse.
Oh,
Okay. I am disappointed in the cross. I think the points were made, but not in the way that I would have made
Okay, so
them.
we're gonna take.
yeah, there was a way better way to do all that.
Yeah.
All right,
I
for the
agree.
jury.
I don't know this defense counsel's history. I don't know how much she's been in trial. I know none of that. All right, let's get up here. All I know is she represented Larry Nasser, but that didn't really go to trial, so she's not generally in Oakland County. I don't think.
Don't intimidate. Next witness. Do you swear or affirm the testimony about to give, or is it case of?
Curious who this guy is.
Okay, so
Yeah.
step up, have a seat, and state your name for the record, spell your first and last name.
Joe Bryan, JoeBrian.
Go ahead.
Thank you.
I've never seen him before.
Sir, how are you employed?
Employed as a detective sergeant.
Maybe-
Okay. Can you keep your voice nice and loud for us, please?
All right,
Thank you. Sergeant, where do you work within the sheriff's office?
I'm assigned to Special Investigations Unit.
Okay, what do you do there?
We conduct major investigations, internal affairs, assist a lot of other departments, anything kind of big we at least help out with.
Okay.
This guy seems
Now,
very
November
cocky.
30th, 2021, were you working that day?
I was,
Were you assigned to assist in the investigation of the Oxford High School shooting?
I was.
And at this time, how long have you been with the sheriff's office?
At that time, 27 years and some change.
Okay. So you're with the Special Investigative Unit now. Where did you work prior to that?
Thanks, Bob, since 2011.
Okay, what about prior to that?
I ran the computer crimes unit for about 8 years. Prior to that, sergeant in jail, sergeant or detective out in Highland, and then the jail.
All right. So did you actually respond to the Oxford High School shooting scene? Did you respond to the shooting scene itself?
Not initially.
Okay. Were you directed to the Oxford substation, the sheriff's office?
I was,
Okay. And for what purpose?
to attempt to do some interviews.
Okay. Now, by the time that you had arrived at the
Jamie, give him some slack. His shirt doesn't button. Come on.
Oakland County Sheriff's Office substation in Oxford, Was the school shooter already in custody?
Yes, he was.
Okay, and was he brought to that location?
He was.
Okay. And during the course of your investigation, did you learn who the school shooter's parents are?
I did.
Okay. And his mother is Jennifer Crumbley?
She is.
She's in court today?
Yes, she is wearing a dark blazer. The defense counsel.
The record will reflect the court identification of the defendant, Jennifer Crumbley.
Thank you. Once you learned who the school shooter's parents were, did you attempt
they don't
to
make them big
speak
enough.
with those individuals?
I did.
Okay, tell us how that came to be.
They call them
I
tents
called
now.
him. I had him come to the substation to talk to me.
Okay, so you learned the identities of James and Jennifer Crumbley and you made a phone call.
Correct.
Okay, so on Friday, we introduced evidence of call logs that showed you contacted James Crumbley about 1:50 in the afternoon, November the 30th. Does that sound accurate to you?
That sounds about right.
Okay. And when you made that phone call, what did you tell them to do?
Just come to substation.
In Oxford?
Yes, sir.
Okay, and did they arrive there?
They did.
Do you recall approximately the time they arrived there?
Ooh, I wonder if we're gonna get some like police interrogation
Around
videos.
2.
We haven't seen any.
We didn't wait much for them to get there.
Okay.
Yeah, that'll be
And
interesting.
again, on Friday,
Yeah,
there was
will
evidence
be,
of their
actually.
GPS data locations that indicate they were there at 1:58 p.m. Does that sound accurate to you?
Yes, sir.
All right. When you conduct interviews with individuals
what time did they say they
pertaining to
arrived?
investigation, criminal investigation, are those interviews generally recorded?
Most of the time.
Is that audio recorded as well as video recorded?
When available,
Yep.
yes.
We got it.
Does the Oxford substation, the sheriff's office, have the capability to record interviews in such a fashion?
They did and do.
Okay. So on November the 30th, 2021, did you interview both James and Jennifer Crumbley?
I did.
Okay, and was that interview recorded?
It was.
Have you had the opportunity to
Did
review
they do it
that
together? We
Yes,
did
sir.
it together.
recording? Does that recording fairly accurately depict your interview?
Yep,
with
we're gonna
James
get
and Jennifer
video.
Crumbley on
All right,
November
cool.
the 30th, 2021?
Yes.
Judge, that's people's 300.
And for anyone who doesn't know me, I keep an open mind on these things, right? If they say something that leads me to believe that they're guilty as hell, then they're
We'll just
guilty
play
as
it for
hell.
the jury, but
But,
before we do, just want to confirm with you,
I just don't see as a matter of law how they could be, but you never know.
Yeah, I think you're right on the matter of law thing.
This is Exhibit 340. It has a date and time stamp. Is that right?
Correct.
Okay, but that timestamp is actually an hour off.
Never talk to cops. That's
Okay,
right.
is it Daylight savings time?
Even with damning facts, I still think the matter of law
I
makes
don't know
it.
why that was an
Okay.
hour. I really
I know.
don't.
That's fair.
Yeah, me
Um,
too.
But we know that they arrived at 1:58 in the afternoon. And did you speak with them immediately after they arrived?
Yes.
Okay, so that would be
Just okay. So when they say that as a matter of Michigan law, the parents can be held responsible for this, the one case that they're citing is a case where a father locked 2 kids in the bedroom for like hours on end, and they were young. They were like 5 and 6, and in that bedroom was a loaded shotgun, and one accidentally killed the other one with it, and that's the case law that they're relying on. So when you say that like they had a duty to protect others, that's the facts and circumstances in which they're relying on. And the Supreme Court said, well, for this case only, we're going to uphold this conviction. And the problem with this case only kind of cases is that they're applied this way. So
the time you
So
spoke
it's
with
okay
them.
to lock them in kennels, but not in bedrooms with guns. Got it.
How long
Yep,
does it take?
exactly.
You know?
The video,
Perfect.
Yeah.
like 15 minutes probably.
It's around 20 minutes or so.
That's it. Only 15 minutes. Okay, cool. Let's watch this thing. I should have gotten more coffee beforehand, but I'm not leaving now.
So Sergeant, as I get this queued up, this would have been right after they found out that their son was taken into custody for the Oxford High School shooting.
258.
Correct.
Just so we can identify everybody. This is you in the blue shirt,
It is.
and the individual to your left in the video is who?
My partner, Rob Miller.
Individual with the hat,
James Crumbley.
and the female in the video.
Jennifer Crumbley.
Okay, and again, this is 1:58 and 59 seconds, November 30th, 2021.
Yes, sir.
Obviously, we don't know all what happened yet, they're still ongoing. Our understanding, he wasn't involved in a school shooting, he was the one who did everything. He said he acted alone. That's basically the only thing we've asked him so far, because there's where our students are people in the audience. I'll use some questions for you, or ask you some questions first before we even start talking to him. Is there, I hate to stop you. Is it possible for me to have a word? My mouth is full. Yes, I'll get it. Super dry. Bring me out. Stay up for
Was there any probably didn't know?
And we do not know. There are several people who've been shot. It's just not hard to get back. But we really need to talk to him. So if we can do that. That's what I understand. But we'll talk about that.
You've never done anything bad.
Jennifer, what did you date of birth? Last name is also Crumbley. And Kate, what is your date of birth? So, we're coming in very early, but when is there an issue this recently? Was that? This morning. What went down this morning? Well, he was writing, yes, show us the picture. He was doodling on a test for a practice test.
Did you think about another lawyer?
That's up to you.
I think we probably should have a lawyer.
I think we can speak
I know.
to the cops. And we'll answer these. And here's our perspective right now. This thing is still very, very fresh.
Right.
Right, people are still on their way to the hospital and such. We need to know what his state of mind is. Is there explosive devices anywhere? Is there other guns anywhere? Did he hide guns, ammunition, explosive devices? Are there any other victims? We need to know these things quite rapidly.
I was in town. I saw all you guys go to.
All I have to say is I just replied to Coffin Liquors, Jennifer Coffin Daffer's tweet. She's on the same page as all of us. That's how amazingly bad this prosecution is. I just had to put it out there.
That's amazing.
She just said, after learning of the testimony below, and she's talking about the horse lady from this morning, I realized it's not the entire case, but at its conclusion, I felt differently than I had before Ethan Crumbley's parents. I don't think his parents had any idea of what he was capable of. It seems like they were at their wits' end through riding horses thought what riding horses could help. They seem hardworking. They seem not to understand the breaking point Ethan was having. Oh my God. If we've got Coffin Daffer on our side, I can't see how this is going to go. And she's like the most prosecute everybody.
She was a glowy.
I know.
She should,
I have so much
if a glowy's on our side, what do we do?
I know, it's kind of scary. I just retweeted it and quoted it and put a link to this stream right now. But I told her, I said,
Good
I'm very
job.
happy to hear your position on this.
I see 5.
We'll find out later her account was hacked.
Yeah, I know, right?
The high school, obviously couldn't get to the high school, turned into the Meyer parking lot, and I saw these kids standing outside. I'm trying to call my son, make sure he's okay, and
He texted me that he loved me.
He actually
and somebody said that there was an active shooter.
35 minutes
I
before he called me, I was
freaked out
I was
because
down
of
to the school.
the
He
situation.
was drawing that on the paper and the counselor called him down.
What did the text say?
No, it was texted to me
Oh.
from the counselor. I texted Ethan at 12:21, you okay? He said, yeah, just got back from lunch. I said, you can talk to us, we won't judge. He goes, I know, thank you, I'm sorry for that, I love you. I said, I love you too. And then, you okay? And hear back. And then he told me about what's going on, and I freaked out and I drove here from work.
She seems extremely stressed out.
That was at 12:21. And you just get
Clearly,
back-
someone who conspired with her son to shoot up a school.
Yeah, yeah.
What, the first hour, second, what time was it?
I got to school at 10:30, not
So it
whatever.
would have been earlier. First or second, I don't know.
And what did he say?
I don't want to interrupt this, but I do. If you guys weren't here for Friday's testimony, then you don't know at 12:42, or rather at 12:21, Jennifer sent a text to Ethan saying, "Are you okay? You know you can talk to us at any time. We won't judge." At 12:42, Ethan responded, "I know, I love you." At that point, he was in the bathroom retrieving his gun from the firearm, or from his backpack, and it's just horrible to think about.
He said he was sorry, he just said, you know,
Do you have an issue with the victim?
No, no.
not that we know of, his best friend, his parents just sent him somewhere to Wisconsin for an OCD rehabilitation. That was his only friend that he had from there all the time, at school. Our dog, our great Pyrenees, just passed away a couple months ago. My mom died back in April. So that's.
So you got all the stressors going on.
They didn't.
I'm going to see if Vio might be able to clean this audio up for us.
Yeah, you guys go over this with him, like, what is that, like, totals? Anybody ask him what the.
No, the counselor just.
The counselor just said, you know, there's no,
I didn't even, honestly, I didn't even like think about that, because
I mean, it's Ethan's like, he's a perfect kid, like, he doesn't do anything, he doesn't get in trouble at school, he doesn't, like,
if that's how,
That's your. What kind of?
it's a six-liter man. It was hidden in our armor, in the case, and the bullets were hidden in a completely different spot, underneath some jeans. I was raised home.
Now, the guy that's under, you saw all the cops.
After I saw the cops, after I found I was an active shooter, after what went on this morning, I immediately raced home. Found the gun in his hand, that's when I called you guys. I called you guys right away, let you know.
Where, how far away is your guys' house from the high school?
like, right.
We live on the street.
I'm not familiar with that.
So, if you walk, it's gonna come to wall. It's really right in the village.
So what we'd like to do, is talk to your son. And obviously you mentioned earlier, our lawyer, he is totally entitled to one. That's gonna be all up to you guys, because his age.
We would like.
I'm messaging Andy right now.
Okay. Can Andy handle,
If Andy can get me something.
we would like a lawyer present from here on out, okay? And there's no disrespect to you guys, that's okay, it's just, we don't, I don't want to have on this one, I only see this stuff on TV, that's cool.
All I know is I got a call from the counselor about that, he talked to me, and we went down there, and
That's all that was.
that's all it was about. And he didn't seem worried about it, and he said he was more welcome to stay at school, or he could go home, and I really wish we
We're taking
could go home.
Did they ask for a lawyer? I was like so focused on Coffin Dapper's thing. Did they ask for a lawyer? Does anyone know?
Did
They
they?
need to stop talking and to ask for a lawyer. But did they ask for one? And is it they did twice?
Oh my! Why? How is that not?
I'm gonna edit this. I'm gonna cut this out. I'll put it up as a short. I'll listen to it again later. You need to be really affirmative. Like, I think I should get a lawyer is not enough. Or you guys get me a lawyer, or with options. You have to definitively say, I want a lawyer now.
Or I want a lawyer dog.
Yeah, don't say that.
I love that. I love that case. That's so fucking annoying.
Do you have any vets or anything like that that you have home that you might need to bring through? No vets, no, is there no treatment for mental health, anything like that? Give me 1 second, I'm gonna get a consignment form, but there's maybe a lot of stuff we have to ask them, as far as just like weight and all that kind of stuff, but one of you guys go with us. Okay. Yeah, no problem.
So if James says he wants a lawyer, but Jennifer didn't, this is being used against Jennifer right now. So if she doesn't say she wants a lawyer, then it should be free to use continuously. It might be excluded from James's testimony. One of the reasons, or James's trial rather, one of the reasons why you might want to bifurcate the case as well.
Give me 1 minute for the form.
I'll go back and clean up the audio when I clip it and see if I can't. I'll post it out there when the day is done. You'll have to go back, but I heard her. Okay, I'll check it out, Jamie.
Any trouble with the law or anything? Nothing. Nothing. I mean, the mediocre is great. I mean, they're up and down, but
He got, if I get jumped to last night, I got on.
somebody, no, a grade. We were talking to him about his grade.
I got on last night.
I'm sorry, it's what?
It's great.
Grades, okay.
It's still jumped. And I got on to him. And I was put off it.
Actually, no, he's gonna be safe. Okay. He's not hurt at all. It's gonna get worse where he's at. At this point right now, it's all pretty fresh. We don't know. Say that many people are hurt. Anybody's died, you don't know. At this point. See about the other children. Family members, you should check on any family members you may be concerned about. See any family members that you want to hurt in. Well, I mean, she's got him. It's just fine. We apologized about last night. We talked about his grades. So, listen, this is why we did it. It's wrong. They should have, unconfused silence. That's all we want to be. Sound fair?
I don't think the police thought of them as suspects.
Not Facebook, Instagram.
But unlike the police in in the Zachariah Anderson case that are just interviewing witnesses as if they were victims, these police, I think, are like properly investigating. Oh, does he have a cell phone? Does he have Instagram? Do you have access to it? Do you have one? They're doing proper investigation, and this is why you need to lawyer up. was a few days later, 8 p.m., that they said that they were looking into potentially charging the parents. I remember it was like early December at some point.
Even like some people have said, the parents should have been read like the whole messages thing. The state's like all these messages, they should have been reading it. There are huge invasions of privacy for teenagers. If you do that, you'll lose all trust that they have in you if you do that. Like, there are ways to do it without having to like just go through their stuff without asking. Like,
I just have my son give me his phone every once in a while, and I go through him right in front of him, but he knows it's coming.
And is he okay with that? So
yeah, he's fine with that. I mean,
then it
it's not his
works.
favorite thing.
Yeah, so it works. It's not like it's an agreement you've come to.
Yeah.
It wasn't an exorbitant amount of money because you were going to. Okay, then he only bought 100 rounds, and so you guys spent 50. So yeah, we go to the shooting range all the time. He goes with you. Yes. I've been trying to teach him safety. I mean,
it was a hobby that they did together. Sure.
Is there like a generator running? This was the day. This was November 30th at 2:58 p.m. It started.
James Robert is.
Honestly, I have no idea. There's going to be some follow-up questions, I assume.
Could I try calling him and tell him those emergencies tomorrow right now? I don't do it.
Jennifer Lynn. Yes, correct. Here's one pop up. I'll leave your phones in there.
I'm going to process this and edit it down and then try to clean up the audio and really listen to it. Oh. There's Ethan.
Ethan, how tall are you? 5'11". How much do you weigh? 180.
Eye color. Blue, grayish. Hair color. Okay, so we were gonna ask you a list of questions about why you did this, and your whole side of the story, your parents want to retain insurance, so we're gonna be asking you questions about the incident that you were involved in. Your parents popped in here to study some basic information, you will have a contact with them eventually. We'll be taking you to, I don't know, Oakland County Jail or Children's Village or Cliff, get you lodged after we take all your clothes and everything else you have on you. Any questions for Randy?
Just how devastating it would be to be those parents sitting in that room, knowing what their son just did. Oh,
Yeah, the mental toll, and you're gonna want to like. It's almost a way to force them or persuade them into talking, because you're like, here's your son. Think about all the think about what the charges and all this stuff. So why don't you help us? And so it's very manipulative, in my opinion.
yeah. I mean, but you do typically the police do sometimes bring the parents in to talk with the when
Yeah.
they're questioning a minor and things like that. But oh my God, the emotional turmoil that these parents have to be going through right now. They're not showing it outwardly, but that would be horrible.
Yeah.
She didn't know.
I don't think we need to ask any questions right now. Okay, pop up, I'll back up. You say you're extra.
Why?
I love you. I love you. I love you. I love you.
I think that was James saying I love you.
I love you. I love you. I love you. I love you.
Didn't even like care.
Before we free go, DLR information. Do you have any questions for us? So typically what happens is, now we haven't done you.
Somebody contact us and let us know where you're going to be. When?
Day or two, could be today, could be tomorrow. Okay, it'll wait it, right? So right now, I really care about.
We understand,
Right, so somebody will be in contact, because of his age. Okay.
Well, that's why I have the cat on screen. I'm young. Although he's not facing us right now. Or she.
Sergeant Brian, person we heard sobbing at the very end, was that the defendant or is that her husband?
Oh, James.
Your Honor, I would object. They're both crying at the end. I think that's misleading.
The only one who can make that is Sergeant Brian.
Okay, well, he has personal knowledge. You can rely on the evidence that you see, okay? You can, all the evidence that will be available for you when you deliberate as well, okay?
And Sergeant, we had some pauses in there. That's because personal information was being obtained from the defendants?
Correct.
Okay. Judge, I'm going to move to admit the transcript of the interview is Exhibit 424. The audio is a little bit garbled over the two TVs that the court has in the courtroom.
Any objection?
Your Honor, I have not seen 424. They have not sent it to me.
We can,
So,
feel free to take a look at my copy while we can,
Okay.
the court can withhold the ruling.
Subject to review, you can let me know in the next 2 days. Okay?
yeah, absolutely, and likely, no objection, but I need to see it. Thanks.
This is a transcript.
Yes, Judge.
All right.
That would be 424. We'll revisit.
Yeah, let me know on this one.
Okay, we'll do.
Certainly. And Sergeant Brian, what was your impression of the defendant's demeanor throughout the interview?
Atypical for what I'm used to on something like that.
What do you mean?
Your Honor, I would object as to the foundation, lack of foundation.
There you go.
Sure. Sergeant Brown, you've been in the sheriff's office for 29 years now?
Yep, a couple months.
Okay. And you've been with the Special Investigative Unit for over 10 years?
Yes.
Okay, and you already told us that that is the unit within the sheriff's office that handles the major investigations?
Yes.
Okay, that includes internal affairs.
Correct.
And it includes homicides.
Correct.
How many interviews of either witnesses or suspects of crimes have you think you've been a part of?
How about parents of a
5,000,
juvenile?
maybe more.
This is something you do on a day-to-day basis?
Every day.
Okay. And you described the defendant's demeanor as atypical?
Correct.
Okay, and tell us why.
Your Honor, I would object as to
Are you
this
fucking
witness's
kidding me?
opinion when the jury can see what's in the video. Every person in life reacts differently. This
Thank
is
you.
very grossly unfair and prejudicial.
That's argument. Counsel's
No,
saying
that's fact. That's fact.
Well, I think an officer with 30 years of experience is in a unique position to give that testimony.
I think the jury can decide for themselves.
Nice. Good call,
The
Judge.
jury's gonna see the evidence, they saw the videotape, they can decide that her behavior is normal or not normal.
Thank you, Judge.
How do people, I guess you can ask, how do people react when their children?
Oh, Judge, don't walk it back.
You've had other cases with children being charged.
Yes, not a school shooting, but yes, I've had many cases where kids have done bad things.
He was 15 at the time.
You've had his other parents with that?
Yes.
Okay. And what you experienced on November the 30th was not consistent with what you
Your Honor,
experienced.
I object again. Same thing.
That was the court's question.
I didn't hear the question.
I was
That
just
wasn't
following up with the court's question, Judge, that in his experience, he's had the opportunity to interview parents.
The
of
jury can
juvenile
come
who's
to
done
their own conclusion.
something illegal.
What's a
Yes.
common reaction that you experience?
Crying, disbelief, why,
Wait, sorry, did we not just see that?
Again, I object. It's irrelevant and it's prejudicial, and no other parents have had
He's
a
got this
child,
look of
their
contempt
child
on his face.
commit a school shooting. He just said, this
Well,
is
that's not
such a
true.
I do
different
not like this
case. Well, he said in his experience, he hasn't talked to anyone else with a school shooting.
He said he's dealt with children who've done.
Judge, you made the right call the first time, then you walked it
This
back.
is like bad, though. I mean, this is
Gang
like,
shootings and school shootings are different.
You guys
They're
can watch
completely
the video
different.
and decide for yourselves, okay?
I have nothing further. Thank you.
Okay.
All right, cool. Cross. There should be no cross on this guy.
it's fair to say that every parent reacts differently when confronted
No, he's not going to say
with
that.
news about their child.
yes.
And
Right.
you
Done.
don't know Jennifer and James Crumbley, correct?
No, I do not.
And prior to this day, you had never met Ethan Crumbley.
No.
So whether their reaction was even normal for how they normally react, you wouldn't even know that.
Correct.
I have nothing further.
Just briefly.
Your Honor, I do have one question, if I could just have a moment. Okay, it's listed with okay. I was just asking about an exhibit, Your Honor, that's listed through Sergeant Brian, but it's coming in through a different.
Okay,
Okay. I'm just trying to make sure I'm keeping track.
okay, yeah.
Thank you.
That was only, the video was, and the transcript were the only ones.
Correct. Correct.
Okay.
In your experience, you ever deal with a parent in this situation who was scrolling through her phone during this interview?
No.
Nothing further.
Oh, come on.
Your
Oh,
Honor,
come
I
on.
recognize its relevance and she's giving the phone to him. I at least asked for recross.
Yes,
Can I ask
recross.
Another question if you want. Go ahead.
While Mrs. Crumbley is showing you things from her phone during the interview, correct?
She showed me the picture, yes, ma'am.
And she's trying to zoom in on the picture and the thing won't zoom in, correct?
Correct.
And she's sitting there scrolling, looking for it on other messages and threads. Or
I don't know.
you don't know? Okay.
Oh,
Fair enough.
now we
Thank
don't
you.
know.
Okay, you can step down and
Thank
make
you, Your Honor.
Thank you. Who's the next witness?
So they just want to show that little bit of the interview. I love that.
Okay. Sorry, I was furiously taking notes. All right. We are done with that witness. That was interesting.
That was pointless. Oh, they
Well,
reacted by scrolling through their phone. Are you serious?
Most of the stuff I feel like is helpful for the defense.
It
That
is.
video, I feel like was helpful to the defense, but I don't know. This is still the state's case in chief, right? When the state is done, you should be convinced beyond a reasonable doubt that this person is guilty before the defense even has a chance to call their witnesses.
Oh, I agree.
Anywhere near there?
No, we weren't there from the beginning, and we won't get there by the end. The problem is does the state, or not the state, does the jury understand that burden, even though they're told it 1,000 times, instead of going the opposite direction, which a lot of people tend to do.
The video helped the defense or state? That's a new poll that's going up.
Yeah, I don't
state neutral. That's going to be the options for you all.
I don't see how that doesn't help the parents. Like, that was clearly two parents distraught over their kid just killing 4 people and injuring a bunch of others. And yeah, you know what I do whenever I'm stressed? I scroll my phone aimlessly because I'm trying to distract myself.
You know what, Rainey, you need to get your ass into the court and then report back to me. No comfort at all for her baby. She's not allowed to touch them or touch in the jail. He's under arrest. They can't touch him.
That's really.
There's
so many things that's messed up here.
I mean, she's probably in shock. Doesn't know.
She isn't. I can tell you just by looking at it that she's in shock. Like, I mean, how you look at your son, because they were trying to, confirm that was their kid. I'm assuming was the intent of that. So you walk in the door, you're like, oh, maybe it's not my kid. Maybe it's not my kid. Maybe it's not my kid. And then the moment you cross the threshold of that door, it's your kid, and then just reality hits all at once. And there's nothing you can do in that moment, that day, or for weeks to really process that, because it's just so overwhelming. I couldn't imagine that if it was my kid. I wouldn't even know what to do. I would probably have very dark thoughts pop in my head because, holy crap, my kid just did that. Where do we go from here? My family's ruined. Even if I don't get charged, my kid's going to jail for a long time or going to a mental institution for inpatient treatment for a long time.
Number of exhibits that we want to tailor from you, pictures of the scene and things like that. So rather than have you hang out while we do that, I'm going to release you for the day.
Oh.
All right. And have you come at 8:30 in the morning.
Let's see if they keep the feed going.
All right.
Might pull up the other feed.
8:30 in the morning. During this trial, do not read, listen to, or watch any news reports about the case. Under the law,
if they cut this feed, I'll see if the Zoom feed
decide
keeps
the
going.
case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media. Do not go on Facebook or post or read Facebook. Do not do research. Do not discuss the case with anyone. Don't read a newspaper. Don't watch the news. Any questions about that? We're making good time, but I don't, you guys hang, it's easier for us to go through the exhibits while you're driving home. It'll be quicker this way, okay? Any questions about the schedule? All right. Okay, I'll see you tomorrow at 8:30, okay?
All rise for the jury.
All right. Let's see if we're going to keep going with.
Okay, so tell me what we're doing now. You guys are spending time together, and
First, Judge, what I'd like to do is go through our exhibits that we have with Detective Stoic. Those are the exhibits that counsel objects to. What I want to do is remove the specific exhibits that we have agreed upon.
Okay.
And then we can come back in here and the court can rule upon the balance.
Okay.
So maybe it'll take 15 or 20 minutes for me to do that. We just went through it.
Okay, so you're gonna let me know.
Yes, that's agreeable to the court.
That's fine. I was trying to figure out at the bench what the exact process is that you were asking about. So you are going to spend some time with Ms. Smith and you're gonna let me know?
Yes.
Okay.
First, I'm gonna fix the exhibit list.
Okay,
and then
sure.
I'll get a copy to Ms. Smith as well as the court, and then I'll speak with Ms. Smith.
Okay.
And if we don't have a complete agreement, we'll let the court know, and then the court can make the eventual ruling.
Is that's today?
Yes, Judge, if
Okay.
the court is able to stay.
I'll stay as forever. I just have to sweet talk the deputies into staying with me, so,
It shouldn't take terribly long.
okay. All right, so you'll let me know.
Yes, Judge.
Is it okay if we just sit here on her?
It is okay to sit here, if you want her.
Are they going off the record?
Can she say?
Yeah, she can. Yeah. Yeah, they're going through exhibits. So, okay, so you're gonna let me know.
Yes.
Please keep in mind that are you guys still gonna film or? Yeah, I don't know, because I wanna make sure I don't get complaints about, me picking up privileged communication or.
I think that's up to you, Your Honor.
It is?
It's your courtroom.
They shouldn't be putting it on the screen if they're talking about information that might not be
Why don't we
publicly
not
available.
record while they're going through exhibits, and then when we go back to on the record and make rulings about it, because she's going to talk to her client, and that's okay. Right, good.
Okay, so now they just cut the audio feed. Yeah, the jury is left. So it sounds like they're going to sit and talk for a bit, but we're not necessarily going to have cameras and audio.
Wonder if they're gonna come back, or if they're just gonna call it for the day.
They just ended the feed. I think what they're going to do is probably go back on the record. So what I'm going to do is, what you do is you travel eastbound on 96 until you reach Telegraph Road, so 696. Head north on Telegraph Road until it dead ends at Dixieland Highway. Just before that, you will see a big building that says 1200 on the top. Pull in there. Go inside, go through the metal detectors, go up to the second floor and go to courtroom 2C. The address is 1200 North Telegraph Road, Pontiac, Michigan. And that is where the trial is being held. She said she's coming back in 15. I don't know if it was 15, but I don't have a feed up. So let me see if I can get into the Zoom. And if I can get into the Zoom, then we'll keep going. And if not, then what I might try to do, it's a dead feed right now. It's not a dead feed. It's like what it was before. Let me pull this up. Okay. Share screen. I got to share the entire screen. So Ken, you might get some feedback.
You're good.
All right. So we're just waiting here. And we'll see what if the court comes back or not. I'm feeling fairly optimistic, not only because I feel like the evidence is going in favor of the defense, but the fact that Coffin Daffer is in our camp, because she is a huge pro-prosecution, pro-state glowy. And the fact that she's former FBI, she's been on court TV all over the place. She thinks Karen Reed is guilty as hell. And for her to then to say, like, in this case, she thinks that the defendant is innocent, is a huge kind of win for anyone in that camp. So if anyone on the jury is of the mindset like, well, she's probably guilty, then I have hopes for this. Does that mean they're actually guilty? Does this mean they're actually guilty? What do you mean?
So what are your thoughts about the jury? Because it sounded like a lot of them were gun owners to some degree, and they were most of them parents. I don't remember.
Yeah, so here I can go through the jury. So juror number one is a white female, works in human resources, has 2 adult children. Her father was a hunter. I gave up watching all the news in all forms 6 years ago. Okay.
That's kind of helpful.
I'm pretty uninformed. Regarding her father's guns, I know my dad's guns were always locked. It was not for the children. So that's what juror number 1 says. Juror number 2, white 26-year-old married male, says he grew up in a strict Christian home. He works in sales for a mortgage industry. He took hunter safety classes when he was 16, but he's not an avid hunter. He's his father had guns and has a concealed carry permit, The juror said he doesn't have strong opinions on guns. He doesn't have cable TV. Well, who has cable TV anymore? Tries to stay away from social media and despises TikTok. Okay.
I think the two so far are kind of more leaning towards the fence, if I had to guess. I have my inferences, but
is sheriff the French spelling, Dave? Oh, probably. Juror number 3, white female hairstylist, says she's familiar with the case, has no issues with guns, and can be impartial. That's what we have. Juror number 4, white female engineer, husband is a lawyer. I'm not thrilled about that, although I like the engineer idea. She said she can be a fair and impartial, and that it's not a good parent, bad parent. It's not a good, bad parent decision the jury will be making in this case, stating it's not what we're here for. So the juror actually said that we're not here to judge the quality of the parenting. Okay,
that might be your foreman. They're going to be the most analytical so far of the jurors you said.
Yeah,
engineering. So the degree that, and they recognize it's not a good parent, bad parent. There's other things at play. So maybe.
However, she says she doesn't go to movie theaters or shopping malls following the mass shooting in Colorado that shook her sense of security.
Okay, so that's
okay.
I mean,
juror number
that's
5.
an interesting one.
I know,
Good.
right? Like that's what I was hearing. Like that's with I think she's juror number 17. We'll get to her, but that's where I was like, I like what she's saying, but I also don't like things that she says. Juror number 5, white female married, has guns in the house and says they are locked up. She has 2 grown children and recalls taking gun safety class as a family when the kids were in elementary school. She works for a bank and her husband is in advertising. I feel like I can be fair, she said. That's the one that maybe might have been approached by media of some sort, because that's the one that was addressed by the judge before they went quiet. Juror number 6 is a white female, married and retired compliance specialist. Her husband is retired meat market owner, I guess, if that's a thing. And her daughter is a special education teacher. She was on a jury many years ago, but remembers little to nothing about the case. Juror number 7, white male doctor. Oh, the doctor, who said, I know that I remember this guy being questioned, who said a lot. He sees a lot of gun violence as a doctor, owns multiple guns, and that he stores them in a safe. He called himself a very strong proponent of the Second Amendment and goes to shooting ranges about once a month, maybe even 2 times a month.
Okay.
He has lost 2 loved ones to suicide by gun.
Okay, I think that's an interesting person too.
Well, I think that's a good one because
that's a great one in a way.
The loved ones that lost that unalived themselves. Did you see it coming? Was it predictable?
Yeah, I mean, I think that too. I think that they still maintain going to the shooting range once a month or so, even with the history there. I don't know if they'll apply their doctor education stuff to anything in the jury room, but I think it's more of a good thing for the defense if they recognize, hey, this isn't, assuming they're rational enough to not just get all emotional about it.
Yeah. I remember reading, what's his name? Wango Tango. What's his name? The musician sings Wango Tango.
I'm not sure who that is off the top of my head.
Man, he's a big hunting advocate. I can't remember his name. Anyways, I was reading his book years ago. This was like 20 years ago. And he was talking about Ted Nugent. Thank you, Ted Nugent. And he talks about when he goes into restaurants, he always sits in a corner where he can see everything. And he has his back to the wall.
I try to do that too, but
I try to do that too. But I remember I was talking to somebody, a liberal friend of mine, when we were reading the book together. And he's like, "It seems a little kind of crazy." And I'm like, "No, it seems like what I would do."
Situational awareness.
Yeah, exactly. Be aware of your surroundings. That's a good thing. All right, juror number 8 is a white male automotive engineer with twin teenagers. He has a collector's gun. Oh yeah, I remember that. That belongs to a relative that served in the war. He has no idea where the bullets are. He's never used it. He doesn't even know if it fires. He doesn't have any ammunition for it.
Okay.
He remembers being a kid and learning how to shoot a shotgun, though he is not into guns as an adult. Beyond owning this collector's item, he seemed okay. He seemed kind of like
I'd call that neutral. It's not
Yeah,
the
it was very
best, but it's
neutral.
not the worst.
Yeah. Juror number 9, white female, first grade teacher, married with two grown children and one older teenager. I don't have guns, but I understand it's legal, she said. Yeah, I didn't like the way she said that, though. I remember her, too. She's like, I know guns are legal, but I don't like them.
I think anyone who is a teacher or has someone in the family or friend that's a teacher will have a bias towards the state because of.
I think so, too.
It's just my thoughts.
Okay, so juror number 10, right? We did 9. So juror number 10, white male, works in vehicle logistics. He owns several guns. And remembers tagging along with his dad to the gun range when he was 10. His best friend is a police officer in a jail, and his girlfriend is a personal trainer, for whatever that means. Juror number 11, single white female, no children. She has a gun for personal protection, worked 16 years as a police officer at the university. Now she handles parking tickets. I remember her too. She's actually like a judge. She's a referee, they call them, for parking tickets in Ann Arbor.
That's
which is
interesting.
which she's like a judge kind of thing. And if she can't resolve the parking tickets, then you go in front of the judge. She seemed okay. She seemed actually kind of like pro defense. I would have kept her. Juror 12, black male, single, no children, works as a manager in sales. His father had a gun and taught him about gun safety. He didn't really have a whole lot to say. I remember him too. He's got kind of dready things, but nothing really significant about him. Juror number 13, single white male who works as a powertrain engineer. He doesn't own a gun, but he went to the shooting range with his girlfriend over the last year for fun. He grew up in Nebraska. He says his engineering brain makes him a good juror, which, to be fair, it does. I like engineers on the jury.
Yeah, I agree.
As he will be able to carefully analyze evidence as it applies to the charges. Defense attorney Shannon Smith joked with him that he wouldn't let engineers, we don't let engineers sit on juries. Well, it's because they like overanalyze things. But for this particular case, I think it would be good. So she says, because they typically see the world as black and white. But there's a lot of gray space in this case. She says the jurors have said he understood and he will be fair. He could be fair. See, I feel like a juror, an engineer, black and white, would be good with this case.
I would hope so.
Let's see.
I really want to see the outcomes of this case. Like, I wish I could jump forward in time for like 2 weeks and see what the hell came out of this.
I know, I do too. Juror number 14 is a white male parole officer who says he's all right. Fair to a fault, he says. He says he's fair to a fault.
That's interesting.
I've never met a parole or probation officer that's fair. And sees success stories in his work involving prisoners who turn their lives around. Well, she shouldn't be a prisoner yet. He's married. He has 2 older teenagers, has guns at home, keeps them in a storage unit. His kids are not interested in guns. Before his 20-year career in law enforcement, he worked for a government Medicaid and food stamp program. Juror number 15 is a single white female who works as an account manager for retail properties, lives with her parents. Okay, They don't really give her age. I was looking for an age. They don't give her age.
That's weird.
Juror number 16 is a white married female with an infant son, works in billing for university students. Oh, is this the U of M? Oh, no. She was originally from the UP, the Upper Peninsula of Michigan, for those who don't know. And used to be a hunter. She remembers getting days off from school as a kid during hunting season, which is a thing that they used to do a lot even down here. But
that's interesting. I've never heard of that.
Opening day of deer season, which is November 15th every year, is a school holiday up in the UP. They get that off.
I know people used to like just go hunting that day, but I don't think it was like a holiday up where I went to school.
Yeah. She remembers getting days off. Oh no, there we go. All right. Her sister was a target of a school shooter that was
Ooh,
stopped. I'm not
why
sure.
was
See,
that?
that's what I'm saying. Like,
That's for cause, I would think, right there. Wouldn't that just be a for cause dismissal? Why would you keep that?
I don't know.
Unless
I don't
the
know.
rest of them were bad.
But like everything else she said was great. Like I grew up in the UP. We hunted all the time. We got days off school to go hunting. And then, oh yeah, but my sister was a target of a school shooter that was
That's
stopped.
a big one, though.
I know.
How traumatized was she by it? Does she hold anyone responsible for it that wasn't the shoot? Like, oh,
I didn't hear any of her questioning. She must have been one that was thrown up on the jury panel on Wednesday. I didn't hear her at all. So white female. So juror number 17, white female, married with 2 school-aged children, and works as a veterinary in veterinarian medicine. This is the one that I was talking about. She said that she feels enraged. When I think about this case, I feel rage. That's what she said. She said of the Oxford shooting, she grew up with guns. Her dad hunted, and her sister is a competitive shooter. See, that's why I was like, it's back and forth with some of these people. Though she said her husband is very anti-guns and just doesn't want them to be in the house.
Did any of the sides use any peremptory strikes while you were there?
Not when I was there, no. It was all challenges for cause, and everyone was removed. Not anyone that was challenged for cause remained on.
Okay.
No, I didn't see any peremptories. I will say that based on this makeup, I would say about half of them were peremptorily challenged, which isn't a lot because each side has 5, so that's 10 total.
Yeah.
So maybe they each used up all of theirs. I wasn't there for Wednesday though, so I don't know. But I will say too about juror number 17, when so there's a question asked as to did you know that this was the Crumbley case when you came down for jury duty? And some of the people said yes, we knew it because we heard the stories on Monday and they showed up on Tuesday, right?
Yeah.
So, but this particular one said no, I had no idea until she was leaving and she grabbed her. How did she say it? She said it in the worst like mom way possible. She said she grabbed her thermos or whatever. And her husband turned to her and said, I'll be thinking of you today. And she said, why? And he said, because they're selecting the Crumbley jurors today. And she said, oh, I didn't know. And but that's the way, like I'm trying to emphasize it the way she did.
So she said one thing and said the other thing too?
Yeah. So she didn't know about it until the morning of, when her husband, who is very anti-gun, turned to her as she grabbed her Yeti. That's how she said it. Well, I turned to grab my Yeti from my husband, and he said, I'll be thinking of you today.
This almost.
Said, why?
I don't know if you'll agree with me on this one, Dave, but this one almost sounds like a bad Fed plot kind of juror. Like they're trying to sneak on the jury, but they can't help but out themselves.
Yeah. At least it wasn't a Stanley. I know, right? It wasn't a Stanley. No, she said her Yeti. Specifically, I made a mental note of it. She said her Yeti. Oh, she has a Yeti. Yes. And her husband filled it up for her and handed it to her as she was getting in the car. And he said,
I'll take my great value thermos. Thank you very much. I'm cheap.
I know. Well, that was the one that I was like, and she was also the one that says that I feel rage. And I was like, if I was the defense counsel, I'd be kicking her. There's too much risk with her. But they didn't. She's still on the stand or still on the jury.
Yeah, I would think that would be enough to argue cause, wouldn't it?
Well, bad prospect. She married a limp-wristed soy boy. Yeah, that's exact. I mean, the husband choice would be like, okay, nope. She makes bad choices. I don't want her on my jury. I believe her background was also somehow in law enforcement, but I can't remember exactly what it was. But now she's in veterinarian medicine. So maybe I don't know. Maybe she just worked on Oakland County prosecutors emailing me.
Oh, did you get in trouble again?
No, it's my case. It's my case.
Okay.
I got a trial coming up in February. Okay, so that's the makeup of the jurors, everybody. I'm going to put that in my Discord too, by the way, if you guys want to read over it later, if anyone is interested. I don't know what's going on with the trial, if they're going to be back. It's been more than 15 minutes.
I think so. I'm not always the best at keeping track of time though, because I've been yelled at for going over like session for like an hour. Like, what are you still doing? Like, I'm busy.
Yeah, but I mean, but at the end of the day, I feel like the defense is still in a good position. Let's see right now. Was the video helpful to the defense, the state, or was it neutral? 62% of you said the defense, 9% said the state, and 29% said neutral.
I'm curious for those who say the state, why do you think it helped the state?
I actually got a message from my sister-in-law who's watching, and for some reason she won't chat, but she said that come chat with us.
Come join us. We're okay here. We're not mean. We love everyone.
She said that she did not hug her son. No comfort at all to her baby.
She probably wasn't allowed to. Or do you mean with the counselor, I guess? Or were you talking?
No, that was during the video.
Okay, yeah, then they probably weren't allowed to.
Come chat with us, sister-in-law, Farrell says. I have questions.
Yeah, we're friends here. We're nice people, I think.
Neutral, yeah, neutral would be in for the defense since she's presumed innocent, right? You have to assume that she's presumed innocent. That's the other thing too. During voir dire, the jury was questioned heavily about, she's innocent, right? And she's proven guilty, and all the jurors, you have to take jurors at their face. What they say. You don't really know what people are thinking, hence this case. But they all said, yeah, we understand that she is absolutely innocent as she sits here right now.
Well, that's at least good.
The judge stressed that, the prosecutor stressed that, as well as the defense attorney. So everyone stressed that to the jury that she is absolutely innocent. You missed the video. That would be the video of Ethan and Jennifer and James in the police department the day of.
Right after he's arrested and they come in to do questioning. Yeah. But I would say, even like you're saying, you have to take them at face value. That's the same thing for me. It's like a client. I have to take them at face value. Like, there's very rare exceptions do I assume someone's lying to me. And I only do that if it's necessary because, pushing that, button can cause trust issues and loss of they may not want to come back. So, I mean, if someone's not willing to open up with me, I can only do so much until I get them to build up trust and rapport, So the jurors, if they want to get on that jury, they're going to lie. If they're being honest, they'll be honest. Unfortunately, there's no way to know.
And again, you could sit there all day long in court and stare at the jury as the questions are, going back and forth, and guess what they're thinking, but we really don't know. I mean, I feel like sometimes I might be I always sit back like this with my arms crossed, and that's supposed to be a defensive side, but this is when I'm listening the most, or I could even have my head down, but I'm listening, I'm not paying attention just because I'm sitting here like this. So if you watch the jury, one of them could be sitting like this the whole time, and you're thinking, this guy doesn't care. He has already made his mind up, when he's in fact actively listening. So it's impossible to know, but for curiosity's sakes, I kind of want to be in the courtroom too, but then I wouldn't be able to bring you guys this awesome trial coverage. So I'm going to sit right here. Why wouldn't they do jury selection a month before to hide it from the news? Well, because
you can't.
You could. Well, you could in theory. So Livingston County, which is in Howell, Michigan, picks their juries for all their trials 1 day per month. They'll bring in thousands of people, and they'll just pick a jury, and they'll cycle people in and out, and then the jury will get notice. Okay, come back in 28 days. That's when your trial is going to start. So Livingston has made it a point to do that. Oakland and Wayne are all pick and go. You pick your jury that day, and you go straight into trial. So
is Livingston a big county though, or
Livingston's not? No.
Okay, that might make sense for them.
Yeah, it probably does. Also, Washtenaw, which is Ann Arbor U of M, they pick their juries ahead of time as well. So, but that's a bigger county too. I mean, it's not as big as Detroit or Oakland, but it's not a small county. It's not like a little rural town like Livingston is. So each court does their own thing.
No, it's jury selection's always like whenever the whole like Johnny Depp was going on and the other cases, like just the whole there's to a point helpful like jury analysis, but it stops being there's very quickly diminishing returns. Like very
Yeah.
quickly. It doesn't go far.
Yeah, you're just kind of fooling yourself and you're just talking about random things, which I try not to do on this case. I try not to get into the analytics of it. I'm just trying to look at the evidence as much as I can, and what it is. And I know way more about this case than any of the other trials that I've ever covered. And I feel like I'm talking too much into the future. Like I talk about the journals. Wait till you see the journals. And I probably shouldn't, because the whole idea behind this is to watch the evidence as it comes in. But I can't help myself sometimes. Julie F says he was reaching out to his mom. She was not allowed to touch him in that holding facility. She was just not going to be able to touch him.
I mean,
that
you
was gonna
also
be a
don't
no-go.
you also don't know if he's wanting embraced or if he wants to, choke his mom because his mom didn't take him home and help him. Like there's at that point there's a risk assessment that has to be done, and
And you notice as soon as she was leaving the room, she asked why. She's angry at him. She's in shock, and then she breaks down crying. So this is not a mother who doesn't care.
Yeah, I've never gotten that impression. Like the news spun it the entire other way. But as every day I've watched the trial so far, and every day watching the preliminary stuff, I've watched that. I never really got like, could they have been better parents? Who can't? Like, I have sat with many people who are shitty parents, but they're still not bad parents. Like they could be better, but they're not abusive. Their family unit works. I'm not necessarily in the place to judge. As long as their kids aren't being abused or neglected, I have to work with that. Is it easy? No, but that doesn't make them, a bad family or abusive or, negligent for manslaughter. Like,
Elephant wants to know if I ever feel like I want to reach out to the defense and give her some tips. I do, and I legitimately thought about it over the weekend because I thought Thursday and Friday was such a train wreck. And there'd be nothing improper about it. I've actually had counsels come up to me when I'm in court and say, this and that, or you should argue this, or aim small, miss small, which is a common thing, when you're arguing the law and different things like that. And it is what it is. So there'd be nothing wrong with me doing it, but then I thought it might have the opposite effect if I tell her like, hey, beyond just like channel 7 and channel 4 watching you, like, oh, I'm also doing this, and there's a whole bunch of other YouTubers watching you. Because
I would leave that out. I would
well,
just say,
but I
hey,
mean, I wanted to let her know, like, hey, here are my thoughts. But then again, you're asking somebody to change up their style in the middle of trial, and that might have a different effect, even if she doesn't do it.
I guess it depends on. You could word it like in the way of, hey, I've been following this. I agreed with your client's, innocence or whatever, and I think these things, these things were effective, but here's how you could do better. That way, it's never like a criticism. So that way, you're always trying to like come off on a positive note.
I know. I thought about how I would phrase an email to her or something, and I did think about it over the weekend about how I would approach her and what I would say and should I, and I just didn't.
I mean, you could always trip, fall down the stairs, and accidentally send an email. Like
I could.
It happens to it happens to me all the time. So.
Oh, anyone who's received a text or something from me knows that I tend to just say things. So it's possible. I actually put in a lot of thought into doing it, and that's probably why I didn't. If I didn't put in a lot of thought, I've been known to call courts live on stream. So if I wasn't putting in so much thought, it probably would have happened by now, but I haven't.
I would also argue putting in a lot of thought tells me that you care enough about the actions and how they could impart on both the person both the counsel and the client, that you're unlikely to try and do anything that would harm them in the long run. So by taking that amount of time to think about it, you're really trying to be the best as possible in whatever you do. So if that makes sense.
No, I appreciate that. I just didn't want to be a negative impact is my biggest thing. Like if I thought for sure it was going to help, then great. But I have my doubts, and it might negatively impact her, so I didn't want to do that. I think someone did say something about the sorry. She did seem way more put together today, by the way. So than she was on Thursday and Friday. So I don't know if she like regrouped mentally or talked to somebody about it, but she seemed way better prepared. Her questioning was still a little messy. It's not the style. I was yelling at her a little bit. It's not my style, but it was way better than it was, and hopefully it just gets better from here because she's making good points.
I think she kind of probably got someone that she trusts to tell her, hey, I get this is a lot of pressure, but you gotta tighten this up a bit. You know, you're really not helping your client in some of this, and it's more about you than the client, and that's where you're failing them. Like,
there were several compound questions. I think somebody in chat said there's too many dots to connect with her questions.
that
Like,
is
if
true.
this, then this, then this, then this, correct? And it's like, what? You know, by the time some of her questions, by the time you get to the answer, you forgot what the question was because there's so
I'm
much
losing
buildup to it.
track. You're losing track. All of chats having like, I'm having to sit here and like I'm listening and I'm like, where the hell are we going with this? And like when she makes the point, I'm like, that was 20 minutes ago. So
Yeah, and then she falls into traps with the state's objections, which then further sidetracks her, and then you even get further away from the point she was trying to make. It's just
yeah,
it was a little clumsy. It was definitely clumsy. Today was much better.
she gets thrown off too easily by the state. I think the objections really screw with her style.
Well, that's a leading question tactic. So, you could preface it with, "Would I be correct in saying da 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 da?" Or you could just say it correct, and then the person responds, "Yes or no." This, there's ways to do it, but it's just her style. Anyways, I don't really have anything else to say. I don't know where the court is at. I don't know what's going on. I don't know what I should do here.
Yeah, I'm not sure. I mean, it's 4:20 now.
And we're not going to hear
4:21.
any evidence. If they do anything, they're just going to be arguing about evidentiary issues and who's the next witness and what evidence is going to be redacted. That's really all that's for. One of the
Yeah.
issues was that the state presented like, here's our exhibit 101 and it's 900 pages, but then they're piecemealing, they're pulling out 4 pages of these 900 and there's not a lot of communication.
Yeah, I don't like that, how the state's been doing that, in my opinion. They've been very like shady.
Well, thank you, Phil. I'm glad you stayed awake from me. I'll end early so you can go to sleep now since the court seems to be done.
Yeah, I
But,
guess court went out for milk again.
Yeah, right. Let's see here. Let me close this down. I'm going to end my stream sharing. I'll keep this up just in case they go live with something while I'm getting everything else prepped. But who else is streaming right now? Who do we want to go talk to and say hi to? Is there anything going on that we
I'm
know
not
of?
even sure.
Let's see. Murdaugh is still going on. Oh my God, Murdaugh is still going on. I'm going to send you guys
completely
there.
forgot about that.
I'm going to send you guys to Murdaugh. You guys go check that out. And
I know a couple people in chat were saying that it's looking like he might get another trial, so I don't know what's going on.
I know. I'm going to go watch the rest of that. I did watch a little bit of it during the lunch break, and I was like, ooh, I'm going to have to come back and watch the rest of this. So, all right, folks, I'm going to send you over to Excited Utterance, who's covering the Murdaugh trial. I will be in chat very shortly, and I will, I'll be in there very shortly because I want to watch the rest of this. Thank you very much for the super chats throughout the day. Thank you all for hanging out with me. We're going to get some people in the courtroom come hell or high water because I kind of want to get a glimpse on the jury and see what's going on. But 8:30 tomorrow morning, court will be back and I will be back and we will see you then. Ken, thank you very much, by the way, for joining me.
Yeah, I was going to say thank you for having me on. I know I've just been some random person in your chat. I don't know if you know me from anywhere else. So,
do you have a channel or anything?
Yeah, it's Ken's Counseling Couch. Someone asked in chat earlier, I initially got started on Rakita whenever he was covering the Vic case. And I kind of had a bunch of people say, you should do your own channel. And I haven't done anything in like 8 months because I've been moving and stuff and preparing to move and stuff. I finally just mostly got my office set up now and my home office and still working on my new house. And so it's been fun. So I'm trying to get back to streaming again. And
nice. Cool. Yeah, go check it out. It looks like Stray just put the link in the chat. So guys, go check him out. Go give him a sub. And Scott, this would only be statewide, but you can bet your bottom dollar that other state prosecutors will be looking at this if there's a conviction. So this is going to have impact nationwide.
I guarantee it.
Yeah. But well, Ken, thank you very much. Happy to have you back on too. Especially, I like the psychological. Since we had a school counselor to have your input on this, that was great.
Yeah, so. I'm happy to come on. I'm not doing anything this week, so I'm still working on getting my stuff transferred to my new state to work. So,
nice. Christy, you will be able to take notes. I don't know if you'll be able to have your phone out since you're not technically media, but take a notepad. Absolutely, not a problem. You can have your phone with you. You just probably won't have it out in the courtroom. I think that'll probably be the restriction. So, but all right, very good. You all have the rest of your day. Go tell Excited Utterance I said hi, and I'll join you guys in a few.
Have a good day, everyone.
When I was young.